Hello.
Good afternoon, everyone. We will be starting court momentarily. Just be just a little patient with us. We're getting ready to start. Okay?
Okay.
All right.
Okay. All right. Good afternoon, everyone. We're going to go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams, and at this calendar today, we will address matters for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. As you can see, I'm conducting this hearing by video. I am not there in person with you. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this particular proceeding. When I ask if you understand your rights, this is what I am referring to. Those who receive a signature bond will be reset for the notice. Ms. Bridgewater, what is my reset date?
Yes, Your Honor. It's going to be May the 12th.
All right, those who receive a surety or a cash bond will be reset to our state all-purpose calendar on May the 12th, whereby aspects of the case, including bond and contact, can be revisited. All right, have all defense attorneys had the opportunity to speak with their clients?
Yes, Your Honor.
Your Honor.
Yes, Your Honor.
All right. And are there private attorneys on the line?
Yes, Your Honor. Nicole,
All right.
Mr. Morrison,
Who do you represent?
Mr. Leighton Morrison.
Okay, is that number 27? Can we take that case first?
Yeah.
Okay, Mr. Leighton Morrison, is he coming? Is Mr. Morrison present? All right, thank you. Will we need interpretation today?
Yes, we do. We do need an interpretation, Your Honor.
What position?
But let me find it, Your Honor. It was Morales.
Have you done your interview with the language line, or will you need the interpreter to do the interview?
We already did interview with the language line, Your Honor.
All right, thank you. And this is Mr. Morrison?
Yes, Your Honor.
All right, Mr. Morrison, your case is 26 CR 002728Y. You're charged with simple battery family violence. You have a right to remain silent. You have a right to counsel. And as you can see, I'm conducting this hearing by video. You understand your rights and how I'm holding the hearing today?
Yes, Your Honor.
Thank you. Ms. Stallworth?
Yes, Your Honor. There are 6 prior arrests. There's an '01 conviction from the city of Atlanta, possession of marijuana less than an ounce, a 2000 conviction out of Cobb County, also for possession of marijuana less than an ounce. The last date of arrest was out of Milton, Georgia, for battery family violence. That was no pros in 2024. The recommended level is level 2.
Thank you so much. Ms. Tucker?
Yes, Judge. We're asking for a $2,500 good bond in this case with conditions no further contact with Rachel Morrison and to stay away from this location at 1285 Rolling Links Drive in Alpharetta. You did hear that he had that battery family violence arrest out of 2024. That actually was a case involving this same victim. He completed diversion, which is why it was not processed. So he already had an opportunity. So I don't believe he deserves the opportunity for a signature bond today. The facts in this case, there was a dispute between the husband and his wife, the victim, about him going to Magic City. So she locked him out of the house to go through his phone. He was banging, kicking at the door, screaming, and as soon as she opened it, he slapped her. So for those reasons, he's done this before. We are asking for a $2,500 good bond with conditions no further contact with Miss Morrison and to stay away from that location.
All right. Is Ms. Morrison present and wishes to make a statement? Did we know if she was going to be present today?
We did not have any contact with her. So no, I don't know.
Okay. All right, Ms. Mormon, please proceed.
Yes, Your Honor. Mr. Morrison is 47 years old. He's been a resident of the Atlanta area for well over 30 years. He has very limited criminal history. I think it was read that the last conviction was 26 years ago for marijuana. He is full-time employed. He's the founder of Generation Now, an extremely successful, well-known, recognized nationally record label. The victim in this case is his wife. They've been married just about 10 years. They have been together since well before then. They share 4 children together, and the incident location was the marital home. Mr. Morrison was completely cooperative with law enforcement upon their arrival. He gave a completely honest statement that was verified by video. I think the state did leave out the conduct of Ms. Morrison, but I'll leave that for later. I would ask the court for a signature bond. I did reach out to Ms. Morrison. I just got her contact information about 30 minutes ago. That was unsuccessful. I would ask for no violent contact, but given that we don't have the position of Ms. Morrison, if the court is inclined at this time to order no contact, I would ask that Mr. Morrison is allowed with police escort or law enforcement escort to return to the residence to obtain some of his belongings. But given the history, I would ask for a signature bond, Your Honor.
Defendant's going to receive $1,000 good bond. He is to have no contact with Ms. Morrison at this time. That can be revisited at a later date.
and he's to stay away from that location. He can return one time with a member of law enforcement to collect any items. He's to have no alcohol, drugs, or weapons, and the case will be reset to the May 12th calendar, whereby aspects can be revisited. Is there anything additional, Ms. Tucker or Ms. Mormon?
No, Your Honor, thank you.
All right, with that, best of luck to you, Mr. Morrison. And Ms. Mormon, does that conclude your business today?
It does, Your Honor. May I be excused?
Yes, you may. Take care. Have a wonderful afternoon, and see you soon. Are there other private attorneys on the line? Okay. And is the interpreter on the line?
Logging on around 2:30.
2:30. Okay. And I'm sorry, was there someone sounding and said there was another private attorney on the line? Okay. All right. Who do we have next?
We go to South Annex. We got a South Annex.
All right. Who's at the South Annex?
Miles Bledsoe.
Oh,
Is he positions 1 and 2? You said Bledsoe?
Yes, sir.
Okay.
thank you, Mr. Jordan. I appreciate that. All right, Mr. Bledsoe, you have two cases today, 26 CR 002718Y. You're charged with criminal trespass and damage in that case. You also have 26 CR 002720Y, in which you're charged with fleeing and eluding, reckless driving, and 2 counts of reckless driving. You understand your rights today?
Yes, ma'am.
Thank you. Ms. Stallworth?
There's an open case, 26 PI 003373 for aggravated assault, false imprisonment, simple battery, family violence, and theft by taking. The recommended level is level 1.
All right, thank you. Ms. Tucker?
Yes, Judge. In position 1, the criminal trespass, we're asking for a $1,500 good bond with conditions no further violent contact with Sharia Bledsoe, which is his mother. And in position 2, we're asking for 2,500 on the fleeing, 500 on each of the reckless drivings for a total of 3,500. That's going to be good. The facts of the criminal trespass case, the victim, his mother, did not want her son living with her anymore due to increasing aggression towards her. So she changed the PIN code to enter the residence, and he was banging the door so much he damaged the door frame and the lock. We did speak with her. She said this defendant has been disobedient, wild, lost his job. She did tell him that he should not come back to the house if he didn't act right, and he actually called the police, and she told the police the same thing. She does want, I do believe she's on. She does want to speak. She does suspect possible drug usage because he doesn't act like this normally, and his friends and family say the same thing. She does want him around. He is still her child, so we are asking for no further violent contact, and we're not asking for a stay away. However, considering the facts in count 2, we are not asking for a signature bond. We're asking for that 1,500 good bond in count 1. In count 2, he was driving over 100 miles an hour down Georgia 400. He was swerving in and out of traffic and driving on the shoulder, all just to get away from officers when they realized he had a warrant out for that aggravated assault. So there's obvious proof there of fleeing. As well as, this is 3 cases now immediately back to back to back, so the risk of reoffense is high. We're asking for that $3,500 total on count 2, 1,500 on count 1.
All right, thank you. Is Ms. Bledsoe, Ms. Sharia Bledsoe present and wishes to make a statement very quickly? If so, please unmute, raise your right hand very quickly. All right, Mr. Shataya?
Yes, Your Honor, thank you. The defense requests the lowest bond amount possible on both cases for Mr. Bledsoe. Your Honor, he is 17 years old. He's currently a high school junior. I know he does live with his mom. He told me that while he goes to school, although he's going to school, he also has a job in the fast food industry. He recently got that job, and before that, he had two different jobs, all working on a part-time basis. He is a lifelong resident of the Atlanta area, Your Honor, and he is a minimal flight risk. So I would ask this court to consider the lowest reasonable bond amount for both cases.
All right, thank you. For position one, defendant's going to receive $1,000 good bond. He's to have no further violent contact with the alleged victim, have no alcohol, drugs, weapons. Position two is going to be a little bit different. I am going to send him through pretrial per judge. It's going to be a $1,500 signature bond at level 2 with $500 on each count. I am going to require that he take the Alive at 25 class, and he is not to drive until completion of that Alive at 25 course. He's to have no alcohol, drugs, or weapons, and he's also going to do 15 hours of community service. Is there anything additional from the state or from the defense?
No, Your Honor.
All right, and I am going to require that he be on pretrial the entire year, not just the 6 months. All right, best of luck to you, Mr. Bledsoe. That concludes your case for today. Who do we have next?
All right, thank you.
Next is position 6, Ms. Centron.
All right, Ms. Centron, your case is 26 CR 002723A. You're charged with theft by taking. Do you understand your rights?
Yes, ma'am.
Thank you, Ms. Stallworth.
There are 12 prior arrests. There's an open case 25 SC 006199, giving false info, theft by receiving stolen property, theft by shoplifting, possession and use of drug-related objects, and identity theft fraud. Also on first offender probation for case number 24 SC 000995, criminal trespass, possession of methamphetamine with intent to distribute, possession and use of drug-related objects. Also on probation for case number 24 SC 004435, BGCSA, possession of controlled substance in Schedule 1 or 2 with intent to distribute. There's a 2023 conviction for criminal trespass from Fulton, a 2022 conviction out of Fulton for criminal trespass, and another 2022 conviction also out of Fulton for criminal trespass and obstruction of law enforcement officers. Nothing further.
Thank you, Ms. Tucker.
Yes, Judge, you did hear that history of a multitude of thefts: identity theft, theft by receiving, theft by shoplifting, and now it's theft by taking. So we're asking for a $2,000 good bond with conditions no further contact with Deborah Humphrey Haynes, and to stay away from 700 Old Roswell Lakes Parkway in Roswell. The facts in this case, the victim had a package delivered to her business. The defendant was walking by and just took the package. She was caught on ring camera doing so, and this package was a $750 water hydrogenator. So pretty substantial. But based on the history, we're asking for that $2,000 good bond with conditions no further contact with the victim and to stay away from her location.
All right, thank you. Mr. Shataya?
Thank you, Your Honor. Ms. Cintron is 27 years old. She told me that she is a lifelong resident of Atlanta. She's a native. She's a minimal flight risk. She told me that currently she works as a dishwasher and busser at a restaurant. She started that job just 3 to 4 weeks ago, and that she needs to get back as soon as possible to avoid losing that job. She takes care of 2 children, Your Honor. She has a 1-year-old daughter and a 7-year-old son. Currently, her mom is helping take care of them, but then the mom has to miss work so that she can be with the children. And she also informed me, Your Honor, Ms. Cintron, that she got through school as far as the 9th grade, and currently she's doing online classes so that she can. She's working so that she can work towards a degree, I believe a GED. With all that said, Your Honor, I ask this court to consider the lowest bond amount possible, maybe in the $1,000 to $2,000 range for a surety bond.
All right, the defendant's going to receive $1,000 surety bond. She's to have no contact with the alleged victim, stay away from that location, and have no alcohol, drugs, or weapons. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Ms. Cintron. Who do we have next?
Going back to South Annex.
All right, who's at the South Annex?
Nasir Gillespie.
I'm sorry, what was your name?
Nasir Gillespie.
Gillespie.
All right, Mr. Gillespie, your case is 26 CR 002704A. You're charged with battery. Do you understand your rights?
Yes, ma'am.
Thank you. Ms. Stallworth? I can't hear you. You're muted, Ms. Stallworth.
My apologies. No prior history. Recommended level 1.
Thank you so much, Ms. Tucker.
Yes, Judge. I believe I sent a. Oh, never mind, never mind. We didn't get in touch with the victim, so I did not do a consent bond in this case. We'd be asking for $1,000 good bond, with no further contact with Jasmine Moore. And the address that was in the incident report was 800 Hitchens Road. We would just ask for a stay away from that, although I'm not really sure if that actually happened here. This incident occurred on the bus on the way to school. The defendant sat by the victim, asked for her phone, started to go through it, saw some things he didn't like, so he punched this victim in the face, leaving a bruise on her right cheek. And this was captured on video from the bus surveillance. Like I said, we were not able to get in touch with this victim, so we're just asking for that $1,000 good bond with no further contact with Jasmine Moore, and a stay away from this 800 Hitchens Road in Atlanta location.
Right. If this happened on the bus, what is the 800 Hitchens? Where the bus was, or
I'm not sure. I'm
Doesn't
not
seem like
sure.
so practical. Okay. Is Jasmine Moore present, or her parents, perhaps, in light of the age in the bus? Okay. Ms. McLeod?
Yes, Your Honor. I am asking for signature bond with my client, and we are perfectly okay with no further contact with this young lady. My client absolutely denies the allegations in the warrant, Your Honor. He said he did not go through her phone and they were just sort of playing around. He was absolutely shocked. And so was his mom when I spoke to her that this young lady had actually called the police because apparently she did not call at that time. They believe that she's upset because he's not interested in pursuing a relationship with her any longer, Your Honor. We're fine with the no further contact with her. But I do believe they attend the same school, so that may be an issue. But my client is okay with no further contact with her. There's nowhere to stay away. His mom is on the Zoom as well, Your Honor.
All right. Defendant's going to receive a $2,000 signature bond at level 1 through pretrial services. He's going to take 2 of the anger awareness courses. He's to have no alcohol, no drugs, no weapons, and he is to have absolutely no contact with Miss Moore. If he sees her, he should stay away, maintain space. And the case will be reset for the notice. Is there anything additional from the state of the defense?
No, Your Honor, nothing further.
All right. Best of luck to you, sir. That concludes your case for today. Who do we have next?
Thank you.
Next, we have Miss Davidson, position 10. Oh, no, I'm sorry. We still got one more for South Annex, Your Honor.
Oh, one more South Annex. Who's at the South Annex?
No, that was the only 2 we had for South Annex.
All right, South Annex and issues. Take care. So we'll go to Miss Davidson. Miss Davidson, your case is
I have
26
to check in.
CR 002719D. You're charged with criminal trespass and damage to property. Do you understand your rights?
Yes.
Thank you. Ms. Stallworth?
There are 3 prior arrests. There's an open case, 22 SC 182720, for false statements. There's a 2023 conviction out of Fulton for criminal trespass and willful obstruction of law enforcement officers. Recommended level 2.
I'm sorry, level 2?
Yes,
Okay.
ma'am.
Thank you. Ms. Tucker?
Yes, Judge. I did send a consent bond in this case to Mr. Chitai. Did you get a chance to review it with the defendant?
Yes, yes, Ms. Tucker and Your Honor, I reviewed it with the defendant, and she refused. She would like to have the bond hearing, and I did inform her that it would be advisable to take a signature bond, but we're going to have the hearing instead.
Okay, thank you, Ms. Tucker. Please proceed.
Okay, then the state would recommend a $2,000 good bond. Conditions: no further contact with Sherry and Davidson, her mother, and to stay away from 355 Fairburn Road in Atlanta. This victim, her mother, and the defendant were having a verbal argument, so the defendant left the home but snatched the Ring doorbell cam on the way out, damaging it, leaving it inoperable. We did not get a chance to get in touch with Miss Davidson, but considering she does have some history of fleeing, a history of hit and run, those are both, that's why she was recommended for level 2, not 1. We believe she's a flight risk. We're asking for a $2,000 good bond, no further contact, and to stay away.
All right, is Ms. Davidson present and wishes to make a statement? Anyone who's driving while this is going on is going to be removed from the Zoom. You cannot be driving while we're in court, regardless of your status, victim, defendant, or otherwise. Is Ms. Davidson present and wishes to make a statement? Okay, Mr. Shataya.
Thank you, Your Honor. Ms. Davidson's 32 years old. She informed me that she is an Atlanta native, high school graduate. She recently started a job at Whistle Express Car Wash in Sandy Springs. She is currently a gate attendant there. She has no objection to the stay away, and she requests the lowest bond amount possible from this court.
Right. Okay. Defendant's going to receive. Okay, defendant's going to receive a $2,000 signature bond at level 1 through pretrial services. She's to have no contact with. I'm sorry, Miss Tucker. It was a no contact recommendation.
It was no contact, and pretrial recommended level 2.
Okay. She's at let me go back. It's gonna be a $2,000 signature bond at level 2 through pretrial services. She's to have no contact with the alleged victim. Stay away from that location. She can return one time with a member of law enforcement to get any items. She's to have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right, this matter will be reset for the notice. Best of luck to you, ma'am. Who do we have next?
Next is position 13, Miss Dunn.
Ms. Dunn, your case is 26CR002710G. You're charged with 2 counts of simple battery. Do you understand rights?
Yes, ma'am.
Thank you, Ms. Stallworth.
No prior history. Recommended UJR jail.
Thank you, Ms. Tucker.
Yes, Judge, we'd be asking for a $1,000 good bond on each count for a total of $2,000. With conditions no further contact with Jaden Neely, no further contact with Ronnie Neely, and to stay away from 3800 Cypress Point Drive in Union City. The facts allege that the witness, Sylvia Neely, said the defendant came into the home to speak with her brother-in-law, the victim Jaden Neely. They began fighting, and so victim Ronnie Neely tried to break it up and was intentionally knocked into the car. Jaden Neely had a ripped shirt afterwards. So there was violence towards multiple parties in this case. We are asking for a $1,000 good bond on each for a total of $2,000. No further contacts and the stay away.
All right, Mr. Ronnie Neely, I see you on Zoom. You're not required to make a statement, but if you wish to, this is your opportunity. Please turn on your camera and raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right. What I'm most interested in and concerned with today is not the facts about what happened, but I'm more concerned with any concerns you have for your safety and whether you wish to have contact with the defendant. You'll have lots of other opportunities to flesh out the facts of this case. What would you like to tell me, Mr. Neely?
I would just like to say I was actually attending today because we wanted to drop the charges. I understand she was basically acting out of emotion. She's actually a good person, so I was really just trying to get paperwork just in case I couldn't make it to work or anything.
I appreciate you coming to court to make that statement. Is Mr. Jaden Neely present and wishes to make a statement?
I think he might be at work right now.
Okay. All right. Thank you, Mr. Neely. Mr. Shataya?
Thank you, Your Honor. Ms. Dunn is 24 years old. She told me that she moved to Atlanta in 2010, so she's been here for 16 years now. She's completed some college and she's going back to school in the fall to complete a degree in nursing. Currently, she is a registered behavioral technician. She will have done that for 4 years as of November of this year. And her job is essentially she works around autistic children, Your Honor, and she provides therapy for them. The defense asks for the lowest bond amount possible, Your Honor, and we'll more specifically a signature bond.
All right, defendant's gonna receive a $2,000 signature bond at level 1 through pretrial services, 1,000 on each count. She's to have no further violent contact with either of the alleged victims. However, she's gonna take the 2-day anger awareness course. She's to have no alcohol, no drugs, no weapons, and this matter will be reset for the notice. Best of luck to all parties concerned. The case is closed for today. Who do we have next?
Thank you, Your Honor.
Position,
Thank you.
position 22, Miss Ireland.
All right, Ms. Ireland, good afternoon. Your case is 26 CR 002-690D. You're charged with 2 counts of battery family violence and 1 count of cruelty in the third. Do you understand your rights today?
I have what? What's the charges?
2 counts battery family violence and 2 counts of cruelty to children in the 3rd degree. You understand your rights? Not do you understand the charges, but do you understand the rights that you have today?
Yes, ma'am.
All right, thank you so much. Ms. Stallworth?
There are 7 cycles total, 5 from the state of Texas. There is an open case out of Upson County, Georgia for driving while license suspended or revoked and DUI. There's a 2026 FTA from Upson County, Georgia, a 2014 conviction out for theft of property, and another 2014 conviction out of Houston, Texas for possession of marijuana less than 2 ounce. The recommended level is level 3.
All right, thank you. Mrs. Sirocco?
Yes, Your Honor, and there should be just one cruelty to children charge there on this case. Did you see 2?
No, 2 counts battery family violence, 1 count cruelty to children in the third. Is that correct?
Yes. Your Honor, this was a April 27th incident. Took place at the Chevron at 336 Joseph E. Lowry in Atlanta. Officers were flagged down by a citizen who reported that 2 females were actively fighting at the location. Officer observed the victim, Miss Keosha Treadwell, holding down the defendant on the floor inside the gas station. Law enforcement was able to arrive and separate the 2, and the victim explained that she and the defendant had met several years ago in the shelter, and the victim has since left, got her own apartment, and allowed the defendant to stay with her for a few months, and the defendant had started doing drugs. The victim wanted her out of the house, and they haven't gotten along since. The defendant admitted when they spoke with her that she walked up on Ms. Treadwell, claiming it was due to her antagonizing her via text and social media. The officers reviewed that camera footage, and it showed the defendant walking up to where Miss Treadwell was, standing right in front of her, and starting to punch her. So clearly the predominant aggressor here, the primary aggressor, the officer did observe scratches and bruising to both women's faces. And I did see as well, we did speak with Miss Treadwell. She confirmed the events in the warrant. And she confirmed that her daughter was actually there and present at the time. She wants no contact with the defendant here. Her defendant to have no contact with her. The juvenile KT is her daughter that was present, and she wants the defendant to have a cash bond. We are asking for a surety bond in this case. There is a 2026 FTA. This is said to have taken place in front of a child. We are therefore recommending a $2,500 surety, 1,000 for each battery family violence, and 500 on the cruelty to children in the third. No further contact with Keosha Treadwell. No further contact with juvenile KT. Stay away from the apartment complex, 1631 Stanton Road in Atlanta. We would allow for a one-time law enforcement escort to see if Miss Treadwell still lives there. It's clearly don't live together anymore, but it's unclear who necessarily moved out, unless she can clarify for us here today during court. If we could sound from Miss Treadwell, Your Honor.
All right, is Ms. Treadwell present? Wishes to make a statement?
Hi, Mr. Chataya?
Thank you, Your Honor. Miss Ireland is 35 years old. She informed me that she's been living in Atlanta for the past 8 to 9 years. She completed a bachelor's degree in computer science back in 2014. She told me that she currently works as an inventory control specialist. She's had that role for the past 7 years, but that specific job at her current company she's had for about for about 3 years, I believe. She also told me that she has a 7-year-old daughter that she looks after, and currently she has a friend that's helping her take care of that daughter, but she needs to be able to take care of her as soon as she can. So she requests the lowest bond amount possible, Your Honor. I understand it's a battered family violence charge, so she would be requesting, well, she would like to request a signature bond if that's possible to get that from this court. But she would also, if that's not possible, then she requests a surety bond within the $1,000 to $2,000 range.
All right, the defendant, excuse me, will receive a $1,500 surety bond, 500 on each count. She's to have no contact with Ms. Treadwell. Stay away from that location. She can return one time with a member of law enforcement to ascertain whether Ms. Treadwell is there and she wants to return, or to collect her items if Ms. Treadwell is remaining there. She's to have no alcohol, no drugs, no weapons, and this case is going to the May 12th state all-purpose calendar. Is there anything additional?
Your Honor.
All right. Best of luck to you, Miss Ireland. That concludes the case for today. Who do we have next?
Next, we have position 25, Miss Kelly.
All right, Miss Kelly, please come forward. Your case is 26 CR 2731L. In this case, you are charged with reckless conduct and disorderly conduct. Do you understand your rights? Is that a yes, Miss Kelly? You understand? All right, thank you. Miss Stallworth?
Recycled total, 21 from the state of Illinois, 1 from Virginia. There's a 2023 conviction out of Illinois for aggravated unlawful restraint, a 2016 for resisting peace officer, a 2020 out of Fulton for criminal trespass and battery, substantial physical harm, and there are 9 convictions outside of the 10-year period. The recommended level is level 2.
All right, thank you. Ms. Tucker?
Yes, Judge, we're asking for a $2,000 cash bond on each charge for a total of $4,000 cash, with no further contact with Isaiah Moyo, Justice Pierce, or her children, and to stay away from 641 North Avenue, Atlanta. These victims were walking in the park, and Miss Pierce was pushing a stroller with her 2 small children in it. The defendant approached them, came through the bushes. Neither of these parties knew her, and she started making threats. She had a knife with her. She pushed the stroller to try to knock it over. Miss Justice Pierce had to use her leg and grab and stop the stroller from falling over. She did end up injuring her leg. And then this defendant charged at the victim, Isaiah Moyo, so he had to strike her in self-defense, which irritated a pre-existing condition that he had on his hand. And we do have photographs of that for trial. We did speak with both the victims in this case. Miss Pierce confirmed the events in the warrant. She said she was with her fiance, her mom's fiance, her mother, and her children. She heard a lady yelling, turned to her mom regarding this lady. The lady came rushing towards her, so her fiance told her to get the kids and leave. She ran towards Mr. Moyo, tried charging at him. The defendant missed hitting him, but then came towards the kids and her mom, pushed the mom, yelling, "You and these kids are going to die." She was scared for her and her children. She tried to block the defendant. The stroller hit her leg. She did not go to the hospital, but she was very sore. So she did not know her. She did not see a knife, but her mother saw the knife, and she wants a cash bond and no further contact. They were just at the park, and this lady that they did not know came up threatening them, causing a scene. We also spoke with Mr. Moyo. He also confirmed the events in the warrant. He told us he had this previous injury to his hand that he was recovering for, but he had to protect himself and the people he was with by striking her when she was threatening and charging at him. So I don't know if anyone is on Zoom. They indicated they didn't want to speak, but if we may sound for them, it's Miss Pierce and Mr. Moyo.
All right, I'm sounding for Mr. Moyo. If you wish to make a statement, this is your opportunity. All right, at this time, I'm sounding for Miss Pierce. If you wish to make a statement, please turn your camera on and raise your right hand.
I don't want to make a statement.
All right, thank you. Mr. Shataya?
Thank you, Your Honor. Miss Kelly's 37 years old. She's originally from Chicago. She told me that she has an associate's in business management, so she has a fair amount of schooling behind her. She used to work at a transport company before a terrible accident, Judge. Currently, she has no job, and because of that accident, she suffers from seizures and migraines. She applied for SSI disability benefits, and she expects to receive benefits sometime soon. So she expects approval. With that, Your Honor, she requests the lowest bond amount possible.
Does she
given
have a
those
stable
factors.
does she have a stable address, Mr. Shataya?
I don't know what her address is in Atlanta. She told me she is originally from Chicago, so I can.
I guess my concern is does she does she need a social worker visit is my question. Does she have some housing and are there other MH concerns here?
Miss Kelly, do you need a social worker to see you for housing or?
No, I stay with my father. He's helping me through these seizures and stuff.
Okay. All right. Please continue, Mr. Shataya.
That's all I had to say, Your Honor.
All right, thank you. All right, defendant's gonna receive an $8,000 surety bond. It's $4,000 on each count. She's to have absolutely no contact with either of those victims. Stay away from that location. I am gonna ask for a social worker visit to see if a BH is necessary, if not an MH. And her case will be reset to May 12th. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Ms. Kelly. That concludes your case for today. Who do we have next?
Position 38, Miss Thras.
38. All right, Miss Trask, your case is 26 CR 002698G. You're charged with 2 counts of stalking. Do you understand your rights?
Yes, ma'am.
All right, Miss Dahlberg.
No prior history, recommended UJR jail.
All right, thank you. Mr. Sirocco.
Yes, Your Honor. This is an incident that took place over many months here, roughly July 12th, 2024 through February 7th, 2026. Certainly at least on through January 30th of this year, but this took place at 100 Waldridge Trace in Roswell. It's where the victim resides here. Officers had responded to a past stalking complaint, and they made contact with him. The victim's name is Glenn Robinson. He is the roommate of the defendant. He had been receiving threats in the mail about where he lives and works, what type of car he drives. The stalker had been able to reach out to people he's dated or is currently dating, giving the addresses and names of past and current relationships of his, and he's been receiving text messages from that stalker exposing him seeing other people while dating his significant other, and that there have been the past few nights leading up to the 7th here, a gray minivan being driven down his block that stays in front of his house for 30 seconds and leaves. This has been going on for a good amount of time. He's really received a number of letters, mail with no return address or name on the envelope. And he kept the last piece of mail, which he received on January 30th. And the last text he received from this stalker here was on Friday, February 6th. He's changed his number, changed it last year, and still gets these texts from these various numbers. Ultimately, there was a long investigation here. But essentially, through the investigation, they had reason to believe that the defendant was the one. His live-in girlfriend, Miss Trask, was the one responsible here for sending all of this. And she met with law enforcement. She was read her the Miranda warning, and she did waive her rights there. And she ultimately confessed to sending Mr. Robinson fabricated letters in the mail, sending packages. There's an Amazon package to one of the individuals he had been seeing romantically, as well as him, with a sort of innuendo to it, sending text communications to him via secondary phone to mask her number, and confessed as well that she used an audio recording device that she placed in one of Mr. Robinson's rooms, where she recorded and listened to his conversations without his knowledge or consent, which led to her confirming the additional affairs, and then using that to stalk him here. The state's recommendation on the 2 counts of stalking is a total of $5,000 surety. It's been ongoing for some time here. We have not been able to speak with the victim yet. We would, of course, ask the court sound for Mr. Robinson when appropriate. But with this, we are asking for $5,000 surety, the breakdown being $2,500 each. No further contact with Glenn Robinson. Stay away from 100 Waldridge Trace in Roswell. No drugs, weapons, or alcohol while out on bond. And if we could sound for Mr. Robinson, Judge.
All right, is Mr. Robinson present and wishes to make a statement? If so, please unmute, raise your right hand. Hearing none, Mr. Shataya. Again, if
Thank
you all
you.
are driving while on this proceeding, you'll be removed from the Zoom. Please remove anyone from the Zoom who's driving. All right, Mr. Shataya.
Thank you, Your Honor. Ms. Trask has lived in Atlanta for the past 31 years. She's a local. Now, she's 53 years old. She has done some college. She studied computers. However, her current job is a paraprofessional teacher. And my understanding is that she works at South Cobb High School. She's worked there since 2013. And she provides for special needs students, Judge. So I ask this court to consider the lowest bond amount possible.
All right, defendant will receive a $3,000 surety bond, $1,500 on each count. She's to have absolutely no contact with Mr. Robinson, whether through text, phone, email. Sees him, she should go in the other direction, and she's to stay away from that location in Roswell. Have no alcohol, no drugs, no weapons, and this case will go to all purpose on on the 12th of May. Is there anything additional from the state or the defense, Mr. Sirocco, Mr. Shataya?
No, Your
There
Honor.
is not, Your Honor.
All right, best of luck to you, ma'am. That concludes your case. Who do we have next?
Position 39, Ms. Trotter.
All right, Ms. Trotter, good afternoon. Your case is 26 CR 002705L. You're charged with battery, family violence, simple assault, family violence, and disorderly conduct. Do you understand your rights?
Yes.
Thank you. Ms. Stallworth?
No prior history, recommended UJR jail.
Thank you. Mr. Sirocco?
Yes, Your Honor. This was an April 28th incident, 2712 Noble Creek Drive in Atlanta. The officers were dispatched twice that day to the location, actually. The first time they met with the caller, Latoya Trotter, defendant here, stated she wanted the officer to put her son, Jonathan Davis, out of the apartment. Um, she was asked some information regarding his living situation, and essentially he'd been there for 1 month, roughly. His clothing there, dog living in the apartment, property there. So the officer explained to her, "I can't remove your son. You can talk to him and see what's going on." He did state to the officer that he got into an argument with his mom, and she didn't want. He stated an objection to her over her bringing certain company over to the home, and Miss Trotter stated excuse me, she had stated that if the officer didn't take her son out of the apartment, stating to the officer that things would get physical. They certainly did. The officer came back later and was dispatched again later that day and spoke with both parties. Mr. Davis this time was holding a paper towel over his right hand, and Miss Trotter was stating that he had pushed her. The officer asked what transpired, and she stated if she couldn't kick him out, then she would abuse him. That was according to Mr. Davis, and proceeded to enter his room, started throwing things around his room and at him. He had pushed her in defense, and when he pushed her, there was a piece of glass in his hand that ultimately cut his hand. There were belongings on the ground, the officer observed. There was his bed was noticeably wet, and there was a pitcher next to it. And Mr. Davis explained that the defendant had filled a pitcher with water and poured it onto his bed. So a lot going on here. And did pretrial state, did they list that 2008 case? I apologize if I missed that.
I don't think so.
Sorry, Your Honor.
No, go ahead. What is it very quickly?
There was a domestic battery, physical contact, an aggravated assault case, sentenced to 6 months supervision and $250 fine. Presumably a conviction, though I'm not entirely confident whether that was a pretrial disposition or whatnot. But that was from 2008. It does appear to involve family violence there. We are recommending $3,000 total surety, $1,000 on each charge, no further contact with Jonathan Davis. Stay away from 2712 Noble Creek Drive in Atlanta. We'd be fine with a one-time law enforcement escort to see if he still lives at the property, Mr. Davis. No drugs, weapons, or alcohol while out on bond. But we have not spoken with Mr. Davis yet. We'll continue those efforts if the court could sound for him.
All right, is Mr. Davis present? And Mr. Davis is her son, correct?
That's correct, Your Honor.
All right, thank you. Mr. Shataya?
Thank you, Judge. Ms. Trotter has been living in Atlanta for the past 7 years. She's currently 51 years old. She works as an accounts receivable analyst. She's done that for the past 4 years. She has some college behind her. She's done 70 credits in accounting. And she did inform me that her son was just visiting from Illinois, so I would object to a stay away. The police officers can, if she's given an escort, they can verify that he's not there anymore. And Ms. Trotter asks for the lowest bond amount possible, Judge.
All right. Defendant's gonna receive a $3,000 signature bond at level 2 through pretrial services. That'll be $1,000 on each count. She's to have no further contact with the alleged victim. And I'm not going to do the stay away in light of the information that I've received regarding the home, but we can have her return one time with law enforcement to make that determination. If he's there, she's to stay away. If he's gone, then she can return. Is there anything additional?
No, Your Honor.
Thank you.
All right. All right. Best of luck to all parties. Who do we have next?
Position 49, Miss Winfrey.
Ms. Winfrey, your case is 26 CR 0027000F. You're charged with one count of battery family violence. Do you understand your rights?
Yes, ma'am.
Your Honor,
All right.
before we proceed, it's a dual arrest. McQuell
Okay.
Thurman is the other case.
I'm sorry, what was the other person?
Mr. McQuell Thurman, position 35, Judge.
Thank you so much for that, Mrs. Sarko. Ms. Starworth?
Ms. Winfrey has 15 prior arrests. There's a 2022 conviction out of Clayton County for criminal trespass. There are 3 convictions outside of the 10-year period. There's a 2023 FTA out of DeKalb, 2022 FTAs out of Fulton, 2013 FTA out of DeKalb, and the recommended level is level 2.
Thank you, Mrs. Sarko.
Yes, Your Honor. This was an April 27th incident. It took place at the West End MARTA station in Atlanta, 680 Lee Street, Southwest. Miss Regina Winfrey and Mr. McQuell Thurman were observed engaging in a physical fight. They were detained. The CCTV determined they were engaging in a mutual fight here. Lacerations and bruises were observed on both individuals. Ms. Winfrey had a laceration to her left eye. Mr. Thurman had a laceration to his bottom lip. And they both lived together. According to the warrant here, as well, I did see, in addition to all those FTAs that pretrial went through, I did see that simple battery conviction from 2022. That was against a different victim with a prior violent conviction. There are multiple other convictions dating back to 2004. We are recommending a $1,500 surety, no further violent contact with cross-defendant Mr. McQuell Thurman, no drugs, weapons, or alcohol while out on bond. And that is all for the state.
Thank you. Ms. McLeod?
Yes, Your Honor, I am asking for signature bond for my client. This is her husband, Your Honor. And as the state said, both of them were arrested. We are okay with the no further violent contact because, of course, they are married. But I think the signature bond that she was recommended, Your Honor, would be appropriate under the circumstances. Thank you.
Thank you. Defendants will receive $1,000 good bond. She said have no further violent contact with the alleged victim, have no alcohol, no drugs or weapons. In this case, will go to state all purpose on the 12th. Is there anything additional?
No, Your Honor.
All right. Best of
Nothing
luck.
further, Your Honor.
All right. Best of luck to you, Ms. Winfrey. That concludes your case. Would the interpreter turn the camera on, please, so I may swear you in?
Come on.
Please state your name for the
afternoon, Your Honor.
record. Good afternoon. Please state your name for the record.
Lucia Urtuzastegui.
Ms. Urtuzastegui, will you, do you swear or affirm today that you will make an accurate translation from English to Spanish, Spanish to English to the best of your skills, knowledge, and ability?
I do, Your Honor. Could you tell me just what is the position of the case we're hearing today?
I'm gonna find that out myself. Are we ready for the interpretation case now?
Your Honor,
Yes.
before we start with that, can we finish up with position 24, Ms. Jones?
Okay. Can you hold on one moment, Lucia? We take one position before we go to you. I
I
believe
show there's a consent in this case.
right. Ms. Jones should be quick since it's just I think I've already signed the consent here.
Yes.
All right. So Ms. Jones, your case is 26 CR 002730E. In this case, you're charged with battery family violence. Ms. Stallworth, can I still have the history very quickly?
There's no history, recommended level 1.
All right, thank you. And Ms. Tucker, if you'll put that consent onto the record.
Yes, Judge, the state is consenting to a $2,500 signature bond through pretrial services level 1 to have no further violent contact with Antoine Millen and go ahead and start the family violence intervention program.
I'm sorry, Antoine, what was the last name?
Millen, Millon.
All right, is Mr. Millen present? Wishes to make a very brief statement? Okay.
Yeah, I don't want to make no statement though.
Okay, thank you. All right, I'm sorry, and who represented Ms. Jones? Ms. Kim, that was your understanding, you still consent?
I believe it was Mr. Chataya.
Oh, Mr. Chataya, you represented this defendant? Oh, Mr. Chataya, please come back. You there? Well, I signed the consent, so we're and I do. Let me. Those were the terms of the consent bond. Let me just double check.
It was Mr. Jataya.
All right, and the consent bond reads as follows: 2025. Okay, I have the same thing that Ms. Tucker put onto the record. So you'll be released on a signature by Ms. Jones with those conditions. Is ACDC complete?
Yes, Your Honor. Thank
All
you.
right, take care. Have a good afternoon. Bye-bye.
Bye.
All right, we're gonna go back to courtroom 2. What position was the interpretation needed for?
26.
26, thank you. Okay, good afternoon, Mr. Marvin Morales Rodriguez. Your case is 26 CR 002734C.
Buenas tardes, del señor Marvin Morales Rodríguez. Su caso es el 26 CR 002734C.
In this case, you're charged with simple battery family violence with the offense date of April the 28th of 2026.
En este caso, su cargo, el cargo, la acusación en contra suya es agresión simple, violencia doméstica, con una fecha de ofensa del 28 de abril del 2026.
You have an absolute right to remain silent. Anything you say can and will be used against you.
Tiene el derecho de permanecer en silencio. Todo lo que diga puede y será usado en contra suya.
You have a right to an attorney, and Ms. Kim is present to represent you today.
Usted tiene el derecho de tener un abogado y la abogada Kim al lado suyo está aquí para representarle el día de hoy.
And as you can see, I'm conducting the hearing today by video. You understand your rights and how I'm conducting the hearing?
Y como usted puede ver, esta audiencia está siendo por medio de video. ¿Entiende usted sus derechos y cómo se está haciendo esta audiencia? Yes.
All right, thank you, Ms. Stallworth.
There's no prior history recommended UJR jail.
La juez indica, primero pregunta sobre su historial y le dicen que no hay historial y que recomiendan un programa de UJR por medio de la cárcel.
All right, Mr. Sirocco.
Yes, Your Honor. This incident took place April 28th. So just yesterday at 563 Eagles Crest Lane in Roswell, a witness had called into 911 and stated that she was watching a man beat a woman in the car in the parking lot of those apartment homes.
Este incidente ocurrió cuando la policía fue llamada al 563 Eagles Crest Lane en la ciudad de Roswell. Los testigos indicaron que vieron a un hombre golpear a una mujer.
The officers were able to locate the defendant and the victim in this case, Romelia Morales Marcario, who is the defendant's wife. Found them at the location.
Se pudieron identificar a la víctima, la señora Ramilia Morales Mercaria, y es su esposa y viven juntos.
Officer observed marks on the defendant's body and saw that the victim had been crying and went with the defendant outside to speak about the incident. He was read and waived his Miranda rights.
El acusado tenía marcas en su cuerpo, la víctima estaba llorando y ella fue a la parte de afuera con el acusado mientras le leían sus derechos constitucionales.
The officer noted a smell of an alcoholic beverage emitting strongly from the defendant as he was speaking to him. The defendant had stated that the victim had struck him because she had caught him texting other women. He denied hitting her.
La policía percibió un aroma de alcohol en el aliento mientras estaban hablando con él. Él indicó que la víctima había sido quien le había pegado a él porque le había encontrado texteándose con otras mujeres.
The officer explained to him that there was a witness and a video of him striking the victim several times, to which he did not respond. The officer then spoke with the victim, who stated that the defendant struck her in the face and tried to grab her hair, at which point she defended herself by fighting back.
Él indicó que él no le había pegado a la víctima, sin embargo, la policía encontró un video que indicaba que él estaba golpeando a la víctima. Entonces, él no dijo nada y la víctima indicó que le había pegado en la cara y le había jalado del pelo.
The witness had stated she was adamant that the defendant struck the victim several times and would write a statement attesting to that. The defendant was arrested, and then I'll proceed with the bond recommendation.
Entonces, la testigo indicó que el acusado le golpeó a la señora varias veces, múltiples veces, y así es como procedió el arresto. En cuanto a lo que nosotros estamos sugiriendo para bono de fianza es lo siguiente.
We have not spoken with Miss Morales Macario yet. We are concerned for her safety with this, and there being a third-party witness who had to call in and prevent any further violence here. The state's recommendation is a $1,500 surety, no further contact with the victim, stay away from 563 Eagles Crest Lane in Roswell, and no drugs, weapons, or alcohol while out on bond.
Recomendación de la fiscalía es un bono de fianza asegurado por $1,500. Una orden judicial de no tener ningún contacto, cero contacto con la víctima. Debe permanecer lejos de la dirección del 563 Eagles Crest Lane. Y durante el tiempo que esté bajo fianza no puede tener ni usar drogas, bebidas alcohólicas o tener ningún arma.
And if we could sound for Miss Morales Macario at this time.
Y queremos ver si es que la señora Morales Mercario se encuentra aquí. And Your Honor, I can sound.
Please.
La señora Ramilia Morales Mercario. Señora Morales, si es que usted se encuentra en la llamada de Zoom, por favor, abra su pantalla, la cámara y el micrófono.
All right, hearing none, Ms. Kim?
Yes, Your Honor. Mr. Morales Rodriguez is 32 years old.
I'm sorry, Ms. Kim, I'm having a hard time hearing you. Could you start again? I apologize.
No problem. My client is 32 years old. He came from Guatemala about 2.5 years ago.
Indica, ahora la juez quiere oír de su abogada defensora, quien indica que usted tiene 32 años de edad, vino de Guatemala hace 2 años y medio.
The complaining witness, Romelia, is not his wife.
Él indica que la señora Ramalia no es su esposa.
She is ex-girlfriend who is currently residing together as a roommate.
Es su exnovia, con quien están viviendo juntos, pero como compañeros de casa, nada más.
And they do not have any child together.
No tienen ningún hijo juntos.
The incident location is actually complaint witness's sister's place.
I'm sorry, Miss Kim, it's witnesses what?
Witness, it's alleged victim's sister has that place. That's the incident location. It's not anybody else.
La ubicación de donde esto ocurrió le pertenece a la hermana de la víctima.
My client has a second grade at the elementary education.
Mi cliente tiene educación del segundo grado.
And right now he works as a landscaper, but his job is unstable. He is a daily laborer.
En este momento él está trabajando en la yarda, pero no es un trabajo estable porque trabaja nada más por días.
And he does not have any other place to reside other than that location. And also, Your Honor, he doesn't have anybody's phone number with him, so he cannot call anyone to bail him out.
Él no tiene ningún otro lugar donde vivir aparte de ese y no se sabe el número de teléfono de nadie que pueda venir a poner la fianza.
We asked for a signature on bond.
Lo que nosotros estamos pidiendo es una fianza únicamente bajo la firma.
Nothing further from defense.
Y eso es todo sobre la defensa.
Okay, Ms. Kim, can you clarify what you're saying about the house? That's not his house, or can you clarify that?
They live together, but the lease is in complaint witness's sister's name. None of my client or complaint witness have the ownership, in a sense.
Y lo que la juez pidió una aclaración de la situación donde vive y su abogada indica que ese lugar es donde usted y la víctima viven como compañeros separados y el contrato está a nombre de la hermana de la víctima.
All right, defendant is going to receive a $2,000 signature bond at level 1 through pretrial services.
Y el fallo de la juez es el siguiente. Va a recibir un bono de fianza por $2,000 únicamente con su firma por medio de la oficina anterior a los juicios que está en la cárcel.
He's to have no contact with the alleged victim.
La orden judicial es ningún contacto con la víctima.
And he's to stay away from that location if she resides there.
Y debe permanecer lejos de esa casa si es que es ahí donde ella vive.
He can determine that by returning one time with a member of law enforcement.
Puede regresar únicamente una vez con un policía escoltado para sacar sus pertenencias.
If she's still there, he'll need to collect his things and leave.
Si es que ella continúa estando ahí, usted tiene que recoger sus pertenencias e irse.
And however, if she's no longer there, he may return to the location.
Si es que ella ya no está ahí, entonces usted puede regresar a esa ubicación.
And he's to have no alcohol, drugs, or weapons.
No puede tener bebidas alcohólicas, drogas o armas mientras está en fianza.
And the case will be reset to the May 12th calendar.
Y el
I'm
caso
sorry,
va
no,
a ser-
I'm sorry, no, that's wrong. Case will be reset for the notice for the signature bond.
y el caso va a ser postergado hasta que tengamos la notificación sobre la fianza bajo firma de esa oficina.
Is there anything additional from State of Defense?
No, Judge.
Defense.
La juez
All right.
pregunta si hay algo más y no, eso es todo. Buena suerte, señor.
All right, best of luck to you, sir. Lucille, before you leave, will you please sound to see if anyone requires your assistance?
Yes, Your Honor. Damas y caballeros, si es que se encuentran en alguna sala de la cárcel o si se encuentran en la llamada de Zoom y necesitan un intérprete en español, por favor, párese si es que están presentes o abran su cámara y su micrófono y déjenos saber si es que están en Zoom.
All right, best of luck to you, sir, and take care, Lucia. Thank you as always. Bye-bye.
Yes, Your Honor. Have a good afternoon. Buena suerte, señor.
All right, who do we have next?
Number 7, Mr. Clayton.
Mr. Clayton, your case is 26 CR 002739L. You're charged with battery, family violence, and 2 counts of cruelty to children and the third. Do you understand your rights today?
Yes.
All right, thank you, Ms. Dollar.
One moment, Your Honor. I don't know if I have this one. Give me just a moment. Let me check.
And we did send a consent bond order. Which PD reviewed this case?
Oh, this was my client, and I will double check about some consent bond really quick.
Ms. Stallworth, if you do have the history, we'll go ahead and put that onto the record.
I have to look it up because I don't think it was on the pool sheet. So if you give me a minute, I can.
Okay. And Ms. Kim, did you review the consent? And will this be a consent bond, or will we be holding a hearing this afternoon?
Let me talk to my client really quick.
Okay.
There's no history, Your Honor.
Okay, thank you. I was assuming that was likely. Thank you, Ms. Stallworth.
And the recommended level was UJR jail. My apologies.
That's fine.
The
And in the
next-
meantime, Ms. Tucker, why don't you put the consent onto the record while Ms. Kim is asking her client?
Yes, Judge. It's going to be $1,000 signature bond through pretrial level 1 on the battery and family violence, a 500 signature bond through level 1 on count 2 cruelty to children, and again a 500 signature bond through pretrial service level 1 on the second count of cruelty for a total of 2,000. With conditions to have no further contact with victim Kiera Mason and to stay away from 595 Magnolia Circle, Palmetto, with a one-time law enforcement escort to the property for their belongings, and a third-party exchange of any of their shared children.
Yes,
All right.
thanks, Your Honor.
I'm sorry, Ms. Kim, if you would just speak a little louder. What did you say?
My client consents to the consent bond.
All right, and Ms. Mason, if you're present, if you wish to make a very brief statement, please unmute, turn on your camera, raise your right hand. All right, hearing none, Mr. Clayton, you'll be released on the consent bond with those conditions. Best of luck to you, sir. Who do we have next?
Number 3, Ms. Bridges.
All right, Ms. Bridges, good afternoon. Your case is 26 CR 0027388H. You're charged with simple battery. Do you understand your rights?
Yes.
All right, thank you, Ms. Stallworth.
No prior history, recommended UJR jail.
Thank you, Ms. Tucker.
Yes, this was another consent bond. Did you have a chance to review it, Ms. Kim?
I believe it is PD.
Or Mr. Chatai?
His client. Let me text him so he can come to the court.
In the meantime, okay, I'm sorry. What will you go ahead and put the recommendation onto the record, Ms. Tucker?
Yes, Judge. So this is a dual arrest case. So the same offer was made to both her and to Miss Gay. And Miss Gay did Miss McLeod did approve for Miss Gay. So this is going to be a $1,500 signature bond through pretrial level 1 to have no further violent contact with Miss Diamond Gay and to enroll in diversion with a $250 fee and an 8-hour anger management course.
Okay. And is Mr. Shataya present? I know you're still interviewing. Oh, he's interviewing at ACDC. It was, Mr. Shataya, there you are. Did your client consent to that?
Your Honor, which client is this? Sorry, I was just on the phone interviewing someone at ACDC.
It's okay. Position 3, Miss Bridges, and Miss Tucker essentially offered a pretrial consent
Yes.
bond with the diversion.
Yes, what's on the consent form? That's what we agreed to.
All right, thank you. Miss Bridges, you're gonna be released on a signature bond with those conditions that's just discussed. Best of luck to you, all right?
On to 18, Ms. Gay.
All right, and that is a consent as well. Miss Gay, good afternoon. Your case is 26 CR 0027378. You're charged with simple battery. Can I have the history for the record very briefly, Ms. Stallworth?
No priors, recommended level 1.
Thank you so much. All right, Ms. Tucker, if you'll put it, I'm assuming it's the same conditions, but will you put it onto the record just the same?
Yes, Judge, the same. It's $1,500 signature bond through pretrial services level 1, a no further violent contact with Oceana Bridges, and to enroll in diversion with a $250 fee and an 8-hour anger management course.
And Ms. McLeod, that was what you agreed and consented to? Oh, Ms. McLeod, I believe I have a signed consent. Let me just confirm. Okay, I do have a consent with those conditions signed by Ms. McLeod, 1,500. Okay, so Ms. Gay, you will be released on the signature bond
with those conditions as just indicated. All right. Best of luck to you, Ms. Kay.
Thank you.
Your Honor, was that my client? I'm so sorry.
It was. I just read through. I saw that you had already signed the consent, so we just let her know she's being released on that consent bond. All right.
Yes, Your Honor.
Thank you. All right. Who do we have next?
45, Ms. Wyman.
All right. Good afternoon, Ms. Weidman. Your case is 26CR002729J. You're charged with battery, family violence, 2 counts. Do you understand your rights?
Yes.
All
And
right.
this is
Thank
a dual
you.
arrest, Judge.
Okay. And who was the other person?
The other person is Cedric Weideman. I'm sure they should be right
46.
next to each other. Yeah.
Okay. Thank you. All right. Thank you. Ms. Stallworth.
Miss Wyman has one prior arrest. There's an open case out of Clayton County for possession of a Schedule II and possession and use of drug-related objects. Their recommended level was level 2.
I'm sorry. The recommended level is level 2.
Yes, Your Honor.
Thank you so much, Mr. Srocco.
Yes, Your Honor. This incident took place April 27th, 2026, 3260 Dodson Drive connector in East Point. It's an apartment complex. Officers arrived there at the location in reference to a husband-wife dispute, made contact with both parties, spoke with first Shakira Weidman, who had called 911. She stated that Cedric woke up with an attitude from the previous night, and she had returned home from drinking with friends, which he did not approve of. Tension the next morning, and there was a dispute over Cedric going to the plasma center, in which she had stated that he had said, "I'm going to my other girl's house." She followed him out the door in an attempt to close that door behind him, up to the door, at which point Cedric, she relayed, grabbed her by the throat and punched her multiple times. And, excuse me, she had bit him in self-defense, she states, before. Oh, and there were 2 juveniles present at the time, juveniles AW and KW. An infant and a 3-year-old. The officer spoke with Cedric Weideman. He stated he had as he'd reached the door following this argument, Miss Shakira had grabbed him by the collar of his shirt and began biting him in an attempt to get her off of him. He grabbed her wrist and pushed her away. He denied striking or choking her. They were both assessed for injuries. There were marks on Mr. Cedric Weideman's person in the form of a bite mark and scratches on his neck and chest. They did speak with one of the juveniles here, and that juvenile had stated that described what had happened with respect to Cedric Weideman and their mom. I believe they're parents of the same child, if I'm not mistaken, but the child had shown a choking motion to describe what the child had witnessed. And when they spoke with the parents of Cedric, they had stated that he has a history of aggressive behavior towards Shakira and toward them. The state's recommendation for Shakira Weideman on the 2 battery family violence charges is a signature bond through pretrial services. We'd recommend 2 days anger awareness. No further contact with the cross defendant Cedric Weideman. No drugs, weapons, or alcohol while out on bond.
Okay. Ms. McCall?
Yes, Your Honor. We are fine with signature bond. I spoke with my client, and she would prefer no further violent contact, essentially because they do share a rather young child. The child that they share together is only 6 months old. And she does, of course, want dad to be involved with the child. So she would prefer no further violent contact.
All right. Thank you. In light of information before me, defendant is going to receive the $4,000 signature bond at level 2 through pretrial services. It's gonna be 2,000 on each count. She's gonna take 2 anger awareness courses and have no further violent contact with the alleged victim. Is there anything additional?
Nothing further, Your Honor.
No, Your
Thank
Honor.
you.
All right, can we do Mr. Weideman?
Absolutely. Number 44.
All right, Mr. Weideman, your case is 26 CR 002726J. In this case, you are charged with 2 counts of simple battery family violence. Do you understand your rights today? All right, thank you. Ms. Starwer.
Yes, Your Honor. He has 9 cycles total, 7 from the state of South Carolina. There is an open case, 25 PI 005681, criminal damage to property, second degree. There's an open case out of Clayton County for possession and use of drug-related objects, possession of a Schedule II, and improper tag display. There's a current hold out of South Carolina, and there are 5 convictions outside of the 10-year period. The recommended level is level 3.
Level 3. Okay, thank you, Mrs. Rocco.
Yes, Your Honor. You've heard the facts here. Just to supplement the history a little, I did see a criminal domestic violence conviction out of South Carolina that does appear to be older, from 2003, but I did want to note that as well. And there is an open case, the 25 PI 005681 for criminal damage to property in the second. That's actually against the boyfriend of Shakira Weideman, uh, for basically damaging the tires of his vehicle with a screwdriver, damages exceeding $500. And after damaging the vehicle, he had stood by the incident location watching for the victim. Verbal contact was made, but there was a report there that the defendant had been stalking Miss Weideman for the past 2 days, prompting 911 calls for service. So it appears to at least have been a history of jealousy here. And we would be concerned here with a signature bond, even though we did ask for that, recommend that in Miss Shakira Weideman's case. We are recommending a $3,000 total surety bond here, 1,500 on each count, no further contact with Shakira Weideman. Stay away from the apartment complex. We are asking for a stay away for him at the 3260 Dodson Drive connector location in East Point, as well as no drugs, weapons, or alcohol while out on bond.
All right, thank you. Ms. Kim?
Yes, Your Honor. My client, Mr. Whiteman, is 51 years old. He was born in South Carolina and he has been residing here in Georgia for more than 18 years. They do have 4 children together. They live together, and complaining witness and my client, they're legally married for the last 2.5 years. After 12th grade, right now he is taking billing coding from Bryan University at Colorado. It is an online school, and he is also working at Amazon. We would like to request for signature on bond and no further violent contact. Thank you.
All right, thank you. Defendant's gonna receive $1,000 surety bond, 500 on each count. He's to have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons, and the case will be reset to state all purpose on the 12th. Is there anything additional?
Can you
No,
have
Your
a
Honor.
10% program, Your Honor?
No, Ms. Kim, it'll be that $1,000 surety. Thank you. All right, who do we have next?
Number 30, Mr. Seville.
Mr. Seville, your case is 26 CR 002715K. You're charged with 2 counts of simple battery family violence. Do you understand, right?
Yes, Your Honor.
All right, thank you, Ms. Sowers.
There are 6 cycles total, 2 from the U.S. Army. There's an open case from the city of Atlanta for driving while license suspended or revoked. There's a 2024 NOLO out of Alpharetta Municipal for driving without valid license. And there's a 2017 conviction from the U.S. Army for larceny of government property. The recommended level is level 2.
All right, thank you, Mrs. Sirocco.
Yes, Your Honor. This incident is from April 14th, 2025, 3000 Continental Parkway in Atlanta. Officers made contact subsequently with the victim, Miracle Smith, Miraqle Smith, who reported a domestic incident that had taken place on the 14th. She explained that the defendant, who's her boyfriend and been living with her at the same residence for over a year, had brought another woman over to their shared location. The defendant, she confronted over the perceived disrespect of bringing a woman into the residence. And during that confrontation, he went up to the restroom, and while he was away, she did start looking through his phone. There was a verbal dispute that ensued wherein the defendant had, she stated, been slammed against the bedroom door there and struck on the right side of her face and shoulder with a closed fist by the defendant. She also stated he threw a game controller at her, but it missed. And before leaving the apartment, he had tried to strike her again, at which point she defended herself with a beer bottle. The video she was able to provide to police here showed the defendant slapping the phone out of her hand and physically striking her. That was uploaded to evidence. We did speak with Miss Smith. She confirmed the events in the warrant. They're no longer together, she says. They were dating for roughly 5 months, but had been living together longer. She had not had contact with the defendant other than the times since this that they attended court for civil matter, being a TPO. They don't share children together. She is requesting a no further contact. Stay away is not needed here. She does not reside at the location. He doesn't want her to know where she lives. And this is the first time she states he's ever been physical with her while residing together. We did see the 2024 battery family violence case. That arrest, I didn't see where it was open out of. I'm not sure if pretrial stated that. But we have additional cause for concern with that, even though this was April 14th of last year incident. We're recommending a $2,500 surety bond, no further contact with Miracle Smith, no drugs, weapons, or alcohol while out on bond, and if we could sound for Ms. Smith.
All right, I see you, Ms. Smith, on the Zoom conference. If you wish to make a statement, please unmute and raise your right hand. However, statements are not required. If you please raise your right hand if you wish to speak.
Yes, sir.
Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, ma'am.
All right.
I do.
All right, please proceed. What would you like to tell me?
I would just like for the safety of me and other women that possibly if he is granted a bond, that it be the highest bond possible. And as you said, no further contact at all. That's pretty much all that I have for that. I just don't want him knowing where I reside or anything.
All right. Thank you, Ms. Smith. I appreciate you making that statement. Ms.
Thank you.
McLeod?
Your Honor, I am seeking a signature bond for my client. I read the warrant, and there is something that is not quite right with all of this. And based on my conversations with my client, I realize that the alleged victim, there's something going on here, Your Honor. I will point out to the court, and it is very clear in the warrant itself, that she called in August alleging an incident which occurred apparently in April of the same year. That in and of itself is rather suspect. My client tells me that she's been making numerous efforts to get money from him. He sees this as a money grab. He's had no contact with her since the incident. He wants no contact with her. He doesn't want her to know where he lives. He wants absolutely no contact with her, Your Honor. So I'm asking for signature bond for him. And as I said, something is not quite right here. Because if she was as afraid as she claims to be, an incident that she's saying happened on the 5th of April, she chose not to make any outcry about this until my client had been long gone from her life. Months later, it makes absolutely no sense. So I'm asking for signature bond for Mr. Seville.
All right,
And just to
defendant.
reiterate, there was that
We
video
want
that
no
she provided to
contact.
police. Ms.
Okay,
McLeod.
defendant's gonna receive a $1,500 surety bond. He's to have absolutely no contact with the alleged victim. stay away from that location. He's to have no alcohol, no drugs, no weapons. Is there anything additional, Mr. Rocco or Ms. McLeod?
No, Your Honor.
All right.
Did you
Best
hear
of,
what kind of bond you gave them, Your Honor? That I
I'm
did not
sorry?
hear.
Oh, it's a
I did not hear what the
$1,500,
bond was.
$1,500 surety and no contact, stay away. Any objections? Well, I'm sure there's objections, but anything further?
Yes, Your Honor. He has no criminal history at all.
Well, that's not quite true. All right. Best of luck to all parties concerned. This matter is now closed. All right. What do we have next?
36, Torian.
All right, Mr. Torian, your case is 26 CR 002740C. Your case, in this case, you're charged with battery family violence and simple battery family violence. You understand, right? All right, Ms. Stallworth.
Yes, Your Honor. He has 3 cycles total. There's an open case, 24 CR 007456C. That will be a bond surrender. It's for battery family violence first offense. And there is an open Clayton County case for driving while license suspended or revoked. The recommended level was level 2 if you decide to place him back on pretrial.
All right, thank you, Mrs. Sirocco.
Yes, Your Honor. This incident here, this took place August 17th, 2025, 3380 Peachtree Road in Atlanta is the address. It's an apartment complex, or at least a residential complex here. The officer had made contact with the victim, Miss Tiana Smalls. She is the defendant's, or at least was at the time, the defendant's live-in girlfriend in the parking lot of the Macy's, actually where the officer met her. She had driven there from the apartment where the incident took place for her safety. She had explained to the officer that she allowed the defendant to borrow her vehicle. He had returned to their apartment in her vehicle around 2:30, and she was supposed to meet a friend a couple of hours earlier. There was an argument took place where the defendant threw her car keys at her, threw a shopping bag at her. She explained that as she was defending herself, the defendant had grabbed her and threw her against the concrete floor of the apartment. There were visible bruises and lacerations observed on both of her arms. The open case that he has in the open battery family violence case, the 24 CR 007456C case, is against the same victim. That was for allegedly throwing her to the ground, causing rug burns to her arm, and then is apparently stated to have bit her as well, leaving a visible bite mark. This was, excuse me, he's in violation of the no further violent contact provision of his bond in that case. We have filed a motion to revoke the victim we've spoken with as well. She has not had contact with the defendant since the altercation, but expressed that they were in a relationship for 2 years, roughly from 2023 to 2025. And throughout the relationship, he was verbally and physically violent with her. That first physical altercation with him beginning in 2024, though there were signs of aggression prior. She, excuse me, stated the defendant had shown signs of jealousy throughout their relationship when it came to a friend of hers, but did not take much offense to it. She did express that the defendant, when they were together, used to make threatening statements prior to physical violence and or often damages property that belonged to her. She is requesting no further contact due to the defendant violating the previous no further violent contact that was set in place in 2024 with the aforementioned open case. We are out of our concern for the victim's safety here. Even though this was an August 17th incident from last year, we have enormous concern for her safety with the violation of bond here, this being his second open violent case against the same victim. And with this being excuse me, yeah, the state's recommendation here is going to be a $7,500 total surety bond. We're recommending $5,000 on the battery family violence, $25 on the simple battery family violence. No further contact with Tiana Smalls. Stay away from the apartment complex at 3380 Peachtree Road Northeast in Atlanta. And no drugs, weapons, or alcohol while out on bond. if we could sound for Ms. Smalls.
All right, is Ms. Smalls present and wishes to make a statement? If so, please turn on your camera and raise your right hand. All right, seeing none, Ms. Kim?
Yes, Your Honor. Mr. Torian is 26 years young, and he was born and raised here in Georgia, Your Honor. Complaining witness and my client have not had any contact for more than like what, 8 months or 9 months. Your Honor, they don't live together. They have no child together. They have not had any contact. Actually, my client is kind of shocked that this came up when he didn't have any contact with her. My client denies the allegation, and Your Honor, we ask for, we have no objection to stay away or no contact since they have not had any anyway. My client has another child with another baby mother, and after graduating from high school 2017, he got a forklift operation certification, and he has been working at Cisco, gainfully employed. And we asked for a signature on bond through pretrial. If Your Honor is not inclined to give him a signature on bond because of the current open case, we asked for the maximum $1,000 surety bond. Thank you.
All right, defendant's gonna receive a $2,500 surety bond, 2,000 on count one, 500 on count two. He's to have no contact with Ms. Small, stay away from that location, have no alcohol, no drugs, no weapons. And that case is going to state all purpose on May 12th. Is there anything additional? All right, best of luck to you, sir. That concludes your case for today.
We have 42, Mr. Westfield.
Good afternoon, Mr. Westfield. Is Mr. Westfield coming?
Westfield. Yeah.
Mr. Westfield doesn't want to come. We want to do someone else?
We're going number 9, Mr. Daly.
All right, Mr. Daly, your case is 26 CR 002721E. You're charged with theft by shoplifting and possession and use of a drug-related object. You understand your rights today? All right, thank you. Ms. Stallworth, may I please have his history?
Yes, Your Honor. He has 20 cycles total, one from Connecticut, 5 from Virginia. He's currently on probation out of DeKalb County for burglary first degree. There are 9 convictions outside of the 10-year period. There's a 2025 FTA from Riverdale, a 2022 FTA from Fulton, and 4 FTAs outside of the 10-year period. The recommended level is level 3.
Thank you. Ms. Tucker, I'm most concerned with where he was and what he took.
Yes, Judge. He was at the Dollar General at 2750 Donald Lee Hollowell Parkway, and he took, which they have reported that he comes in and steals all the time. On this date, he placed these items down at the front of his pants, left without paying. He took car washing materials, including rags, wheel cleaner, towels, air fresheners, totaling $276.33. That's why we are recommending $1,500 on the shoplifting, $500 on the possession of drug-related object. They did find a crack pipe on him, search incident to arrest. So we're asking for that $2,000 good bond with a stay away from the Dollar General.
All right, Mr. Shataya?
Thank you, Your Honor. Mr. Daly is 61 years old. He's lived in Atlanta for the past 4 years. Currently, he lives with his mother. In terms of his schooling, he has a GED, and he also informed Your Honor that he's currently on SSI disability. He has diabetes and high blood pressure. He asks that this court grant him the lowest bond amount that's reasonable.
All right, defendant's gonna receive a $2,000 split bond. It's 1,000 on the theft by shoplifting and 1,000 signature bond through the jail on the possession. So he's got to make bond on that $1,000
He's to stay away from that location on Donnelly Hollowell and have no alcohol, no drugs, no weapons. And that case will be reset to May 12th. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, sir. That concludes your case for today. Who do we have next?
Now we're going to 42, Mr. Westfield.
Mr. Westfield, your case is 26 CR 0027009L. You're charged with battery, family violence, cruelty to children in the third, and obstruction. Do you understand rights?
Yeah.
All right, Ms. Stallworth.
There's one cycle from the state of Pennsylvania. The last date of arrest was December the 5th of 2021 for DUI from Pennsylvania. It was no prof, and the recommended level is UJR jail.
All right, thank you, Mrs. Rocco.
Yes, Your Honor. This incident took place, this was April 28th, so just yesterday, 1425 Spalding Drive. Officers had responded to that location, which was actually the Sandy Springs fire station, in reference to a man and a woman fighting in the roadway in the front of the location with a child present. The officers observed a vehicle parked southbound lane with the doors open, and fire personnel was actively attempting to calm the defendant down. He was elevated emotionally. There was a juvenile on scene, juvenile LT, standing near the defendant, and officers found the victim, Miss Tiana Tucker, on the sidewalk there. She explained that she and the defendant stated to officers that he and the victim, who lives with him and that they're engaged in a relationship with, had gotten into an argument over her being disrespectful to him, and he denied any physical altercation. They then spoke with the victim, who explained that the vehicle was stopped because it got physical, their altercation. There was a laceration observed to her upper lip and the left side of her chin. And ultimately, this began with officers being flagged down by EMS personnel, Mr. Christian Whelan, who witnessed the altercation. Both subjects were out of the vehicle, and the defendant approached the victim and struck him in the mouth. The victim turned to him and stated, "He hit me," and pulling at her bottom lip. And this was all in the presence of that juvenile LT. He was informed, the defendant, that he was being placed under arrest. He did resist arrest, trying to wiggle free from the officer's grasp and disregarding lawful commands here. They ultimately had to leg sweep him to place him into custody. State's recommendation is a signature bond through pretrial services. We are recommending 3 days anger awareness, as well as no further contact with Tiana Tucker. No drugs, weapons, or alcohol while out on bond. We have not spoken with the victim yet. We'll continue those efforts, but if she is online, we hope that she would speak. If the court could sound for her.
All right, is Ms. Tucker present and wishes to make a statement?
I'm present.
All right, please raise your right hand if you wish to make a statement. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do.
All right, thank you. What I'm most concerned with today are any concerns you have for your safety and your desire for contact with the defendant. What would you like to tell me today?
I would just like to say that Nicholas Westfield, we share an 8-month-old child together. It's the first child we've shared together. He's a great father, and he also stepped into the role of being a step parent to my now 6-year-old, who he's known since she was 3. He's never been physically violent with me. So I never stated that he put his hands on me in any way, shape, or form, and he's never been violent with me. He was emotionally upset, but that was about it.
All right. I appreciate you coming to court to make that statement. Ms. Kim?
Yes, we would like to consent to signature of bond and yes, for the violent context, since complaining witness showed up and she expressed that she's not afraid of him. She wants him to return home as a good father. Your Honor, my client has 2 children total, and after getting associate degree for filming and journalism, he has been gainfully employed at Auto Parts Mechanic. Your Honor, we would like to request for a no further violent contact. Thank you.
All right. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services, 1,000 on each count. He's to have no further violent contact with the alleged victim, take the 2-day anger awareness course, and have no alcohol, no drugs, no weapons. Anything additional?
Nothing further from defense, Your Honor.
All right.
They
Veteran-
would still object to the no further violent contact. This incident did just take place yesterday, April 28th, in public. So we would still object.
All right. Thank you, Mrs. Rocco. I appreciate your advocacy. Best of luck to all parties concerned. Who do we have next?
32, Mr. Smith.
All right, good afternoon, Mr. Smith. Your case is 26 CR 0026993Y. You're charged with 3 counts of battery family violence and 1 count of simple battery family violence. Do you understand your rights today?
Yes.
All right, thank you, Ms. Stallworth.
There are 20 prior arrests, currently on probation for trafficking of ecstasy and willful obstruction of law enforcement officers, as well as purchase, possession, manufacture, distribution, or sale of marijuana. There's a 2017 conviction for possession of a Schedule II and purchase, possession, manufacture, distribution, or sale of marijuana. There are 3 convictions outside of the 10-year period. There is a case that's currently under judicial hold for possession of cocaine with intent to distribute and possession of marijuana. Case number 03SC11829. He's also on probation for case number 20SC175217 for trafficking in cocaine and possession of marijuana with intent to distribute. And there are 3 FTAs outside of the 10-year period. The recommended level is level 3.
All right, thank you, Mr. Sirocco.
Yes, Your Honor. This incident took place April 22nd, 2034, Cannon Court, in College Park. And that is the Hotel 1, I believe. The officer made contact with the victim, in this case, juvenile HS. She's the daughter of the defendant. She was ready to go home, informed her father that her cousin would pick her up. There was an argument with respect to that and also her what she was wearing. He had approached her and slapped her on the right side of her face. She told him not to touch her. He slapped her again, and then there was a physical altercation that ensued subsequent to that. Her father had punched her under her left eye and pulled her hair on the right side. There was a braid that was pulled out, damage to her scalp. The victim's mother, Deashal Hobbs, stated she was unaware of the incident until she returned home on April 23rd, at which point she saw the bruise under her daughter's left eye, the scratch under her right nose, and the area where her hair had been pulled out. She reported that she had immediately called the defendant when she saw this, and in that he told her that she was disrespectful, and she was fortunate that he didn't break her arm. When asked about the text messages sent to Deashal Hobbs, this being the subsequent conversation that officers had with the defendant upon making contact, the defendant acknowledged sending a message in which he apologized for putting his hands on his daughter, followed by a series of explicit and threatening statements as well. The officer had observed the injuries with his own eye, and photos were taken of said injuries. We did speak with the mother of the victim, juvenile HS, Ms. Hobbs. She was not there at the time of the incident, and she did relay that her daughter told her what happened. But it was when she and her other child, the sister of the victim, had noticed the injuries. She said, excuse me, they did not go to the hospital. They called the defendant to see what exactly happened here, and he began cursing at her and calling her names as soon as he answered the phone. She said it's their only shared child with the defendant, the mother, and the defendant here is the victim. And this hasn't happened before, according to her. She's does not want, according to the mother, the victim does not want to be around the defendant. The mother did say she thinks she'd prefer a cash bond here as being appropriate, and she's recommending no contact with her daughter. Defendant has a lot robust history here, and I should add on that active probation case, it appears that he was convicted of felony firearms possession charges as well. The state's recommendation is going to be a 3,500 total surety here, 1,000 on each battery family violence, and 500 on the simple battery family violence. We are recommending, if he does bond out, a 2-day anger awareness and a parenting class. No further contact with juvenile HS. Stay away from 2034 Cannon Court in College Park, and no drugs, weapons, or alcohol while out on bond. If we could sound for Miss Hobbs.
All right, is Ms. Hobbs present and wishes to make a statement? All right, hearing none, Ms. Kim.
Yes, Your Honor. Mr. Smith is 51 years old, was born and raised here in Georgia, Your Honor. He has 2 children. One is 22 years old, and the other one is this Gisna that who is complaining with this year. After 11th grade, he successfully completed the GED, and right now he is currently residing with his sister, Your Honor. So the daughter and my client does not live together. So he has no objection to stay away and no contact with her. It seems like the daughter has been very unruly, and he's been out of school twice, being expelled twice. And Your Honor, my client claims that he does not have any open case, and he did not ever have 3 FTA. And Your Honor, it is legal to discipline a child. He feels like his daughter was too spoiled, and it was her who started hitting my client first. And he was kind of very upset about how disrespectful her daughter was. And we asked for signature on bond through a free trial. If Your Honor is not inclined to give him a signature on bond, we ask for the maximum $1,000 total surety bond. Thank you.
All right, defendant is going to receive a $2,000 surety bond, 500 on each count. He's to have no contact with the alleged victim and stay away from that location. He's to have no alcohol, no drugs, no weapons, and the case will be reset to state all purpose on the 12th. Is there anything additional?
Nothing further from defense, Your Honor.
All right, best of luck to you, Mr. Smith. Who do we have next?
Your Honor, what were the conditions for the contact?
No further contact and to stay away.
Okay, thank you.
Yeah.
Number 43, Mr. Whitlock.
I'm sorry, the number again?
43.
And this is Mr. Johnson. Mr. Johnson, good afternoon. Your case is 2060. Yeah. I'm sorry, not Johnson?
No, it's 43, Mr. Whitlock.
Oh, 43. I'm so sorry. Mr. Whitlock, your case is 26CR002702F. You're charged with 2 counts of simple battery family violence. You understand your rights? All right, Ms. Stallworth.
Yes, Mr. Whitlock has 9 cycles total. There are a couple of open cases. The first one is 26 PI 002351, aggravated assault and willful obstruction of law enforcement officers. Also 22 CR 007571F, discharge of firearms on property of another. There's a 2024 conviction out of Cobb County for simple assault, a 2023 NOLO from Douglasville Municipal for driving while license suspended or revoked, a 2023 conviction out of Douglas County for a non-fingerprintable offense, and then an 09 first offender out of Gwinnett for forgery first degree. There's a 2026 FTA out of Fulton. The recommended level is level 3.
All right, thank you. Mrs. Saraka.
Yes, Your Honor. This incident took place just 2 days ago on the 27th at 3040 Delmar Lane in Atlanta. It's an apartment complex. Officers had responded there in reference to a assault between domestic partners. They made contact with the victim, Miss Theodora Smith. She's the live-in girlfriend of the defendant. There was a verbal dispute over infidelity, where she was accused of infidelity. That escalated to a physical assault, where the defendant had grabbed her around her neck and threw her up against the wall. The two lived there. Officers confirmed there was a history of violent contact, and that is certainly the case. The I'll get to victim contact first. We spoke with Miss Theodora Smith. She is well, actually, I got him. 26 PI 002351, the aggravated assault and obstruction. The aggravated assault is against the same victim as here. It was for holding a large knife to her temple and stabbing her in the hand. That's what he was arrested for. He was bonded out on a $21,000 good bond, it looks like he was given, on March 23rd, 2026, the incident being from the day prior. He's in violation of the no further contact provision of that bond. And I believe pretrial may have mentioned it, but the 22 CR, excuse me, 007571F, that open case for discharge of firearms on the property of another, that's currently open here in Fulton as well. In addition to the FTAs and the history of violent cases that he has, in addition to that simple assault conviction from 24, there was arrest for reckless conduct 2022, simple battery, that was against a different victim from 2017, dismissed after he completed pretrial diversion, and battery against a female who's pregnant from 2015, that was ultimately dismissed in 2021. That was, I believe, a intimate partner incident as well. The victim stated that she confirmed she's the victim in that open case in Superior Court, the aggravated assault. He was able to bond out on that case, and the defendant's wife, Lavonda, had told her about a case with her as well, that 2015 case while she was pregnant. They've been together for 6 years, engaged for 3. They don't currently share any children. Unfortunately, they lost a child last year. She confirmed the events in the warrant and said the defendant was drunk and also high on marijuana during the incident. The contact with her neck where he grabbed her, she was able to breathe a little bit during that. She didn't consider that a strangulation. And this is, however, the third time that the defendant's put his hands on her. This has all been because of alleged infidelity and betrayal. And she believes the defendant is a good person, but has substance abuse issues and other psychological issues that he needs to work through. She indicated she may be moving soon, as early as potentially the 1st of May. So she said she was fine with a stay away until 5. Oh, excuse me. The defendant can return on 5/2. She's okay with contact, she states, but to clarify, she does want to stay away. I don't believe she's on Zoom, as she indicated to us, but we're in the process of trying to get her connected with resources, get her those resources. Believe she's in need of a voucher and assistance. Also, we conducted a danger assessment here. She relayed to us there has been physical violence that's gotten more severe, more frequent. He's violently and constantly jealous of her, controls most or all of her daily activities. He's unemployed with an alcohol problem and does follow or spy on her, leaving her threatening notes and messages. And also, she believes that he's capable of killing her. She was determined to be in increased danger from that assessment. With his FTAs from 2026, 2024, history of violence dating back to 2015, with the most recent conviction being that simple assault 2024, that open case against the same victim. She's in an incredible amount of danger here, and we're incredibly concerned for her safety. And there's also, of course, significant risk of him failing to appear for court with his FTAs. We are recommending, therefore, a $5,000 cash bond on this case, Judge. We're recommending $2,500 each. No further contact with Theodora Smith. We would request to stay away from the apartment complex at 3040 Delmar Lane in Atlanta. She says she intends to move out by the 1st. I'd like to give her a few extra days. We're recommending the stay away remain in effect until Monday, May 4th, 2026, and that he go with a law enforcement escort to verify that she has actually vacated the premises. No drugs, weapons, or alcohol while out on bond. And if we can sound for Miss Theodora Smith, if she did happen to join us here today.
All right, is Ms. Smith present, wish to make a statement? If so, please unmute, raise your right hand. All right, Ms. McLeod, please proceed.
Yes, Your Honor. My client is an Army veteran. He is currently fully disabled, Your Honor, so he is unemployed. His income is very limited. My understanding is that the location is my client's home where he lives. He tells me that Miss Smith does not live there. My understanding also is, Your Honor, that she was not supposed to have any contact with him, but she showed up at this location. He denies the allegations completely that any of what she said actually happened, Your Honor. So she was just trying to call me. I was not able to take her call because his case had already been called. So, of course, I don't know what she was going to say to me, but I did notice that she was attempting to call me, Your Honor. As I stated, this is his home and she is not there. He did not go to where she was. She came to his home, Your Honor, and then he tells me he also denies the allegations about infidelity and all of that, although he does say that they had been in a relationship for approximately 7 years. She also has some history herself concerning my client, so they may have a somewhat volatile relationship. But the FTA, Your Honor, was based on the fact that at the time my client was locked up because he had a probation violation for some um, he had a violation of probation and he was locked up for that, and that was in Clayton County. That has now been resolved, Your Honor. He's definitely not in a position to pay a huge bond. I did listen to the state's repetition and pretrial's repetition of his cases, and I believe the only conviction I heard that could even be remotely called violent was for a simple assault. So I would ask the court to consider a signature bond. If the court is disinclined to do so, then a very small cash bond, say $50, so that my client can get out of jail. As I said, he is disabled and he's a veteran. Nothing further, Your Honor.
All right, defendant's going to receive a $5,000 surety bond, $2,500 on each count. He's to have no contact with the alleged victim, stay away from that location, and to have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Mr. Whitlock. That concludes your case for today.
Thank you, Your Honor.
All right.
Number 4, Mr. Brown.
I'm sorry, number 4, we said?
Yes.
Thank you. Mr. Brower, your case is 26 CR 0027360. You're charged with theft by taking. Do you understand your rights?
Yes, Your Honor.
All right, thank you. Ms. Dahlberg?
Yes, Your Honor. He has 12 cycles total. He's currently on probation out of Hall County for DUI drugs, drugs not in original container, and possession and use of drug-related objects. Also on probation out of Richmond County for possession of methamphetamine and willful obstruction of law enforcement officers. Also on first offender probation out of Forsyth County for DUI drugs and purchase, possess, or have control of controlled substance in Schedule 1 or narcotic in Schedule 2. There is an open case out of Richmond County for bail jumping and possession of methamphetamine. There's a 2024 conviction out of Cobb County for theft by taking, and there's a 2024 FTA out of Fulton, 2024 FTA out of Cobb, and 2023 FTA out of Cobb. The recommended level is level 3.
Thank you. Ms. Tucker?
Yes, Judge, you heard that history. He's failing to appear out of multiple counties, offending in multiple counties. We're asking for a $2,000 good bond with conditions no further contact with victim Ryan Clark and to stay away from 6617 Cadence Boulevard in Sandy Springs. The facts allege that 2 packages were stolen from the victim's home by a masked subject wearing an Amazon employee vest and plastic on his arm to hide his tattoos, and he fled in a Home Depot rental van. So the rental van was found on the flock cameras, and that's how they were able to identify the defendant. But based on the facts as well as this history, we're asking for that $2,000 good bond, no further contact, and to stay away from this location.
Thank you. Mr. Shataya?
While the trial was reading his criminal history, my client was shaking his head. Was the right report being read?
Let's confirm, Ms. Stallworth.
Was this John Byraw?
Mr. Brown, let's, the birth
Yes,
date that you had
John
was
Byraw, yes. Date of birth, February 22nd, 2004.
And that's the same history that I had.
Okay. All right, I was just checking. All right, thank you, Your Honor. Mr. Byraw is 22 years old. He told me that he's a lifelong resident of the Atlanta area. He has family living here as well. He has a minimal flight risk. He told me that he is currently in his first year of college at the University of Phoenix. He's majoring in business. He's also been a mobile mechanic since January of this year. And he also informed me, Your Honor, that he turned himself in for this case. Because he has residence here, Your Honor, he is a minimal flight risk. I would ask this court to consider the lowest possible bond for him.
I'm sorry, Ms. Tucker, again, what was the value of what he allegedly took?
I don't believe it was in the warrant.
Okay. And what was I'm sorry, the locations I have it is that Cadence Boulevard, but what was it? That's
6617 Cadence Boulevard. It's a home, a residence.
Okay. All right. Defendant's going to receive $1,000 surety bond. He's to stay away from that location and have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
You said that should come out, right?
$1,000 surety bond.
Number 8 is Curly Legon. Yeah.
All right. Mr. Cullen Lee Gong, your case is 26CR002733B. You're charged with theft by shoplifting and criminal trespass. Do you understand your rights today?
Yes, ma'am.
Thank you, Ms. Stallworth.
There are 4 cycles total, 2 from the state of Virginia. There's a 2018 conviction out of DeKalb County for DUI, a 2010 FTA out of Virginia, and a 2010 conviction out of Virginia for shoplifting, recommended level 1.
All right, thank you. Ms. Tucker?
Yes, Judge. I did not prepare a consent bond in this case, but the state would be fine with a 1,500 signature bond through pretrial level 1 on the shoplifting and a $1,000 signature bond, pretrial level 1 on the criminal trespass. The facts allege he had placed several food items and clothing items totaling $59.28 in his backpack, tried to leave the store without paying. He had just been issued a CT warning here on March 17th for shoplifting in the same store. This was at the Walmart at 844 Cleveland Ave in East Point. So we'd also be asking for a stay away from that location.
All right, Mr. Shataya? Or is it Ms. Kim? You're muted, Mr. Shataya.
No objection to the state's recommendation, Your Honor.
All right, defendant's going to receive a $1,500 surety bond. I'm sorry, getting tired. A $2,000 signature bond at level 1 through pretrial services will be 1,500 on count 1, 500 on count 2. He's to stay away from the Cleveland Avenue Walmart. Have no alcohol, drugs, or weapons. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Number 15, Mr. Fleming.
Mr. Fleming, your case is 26 CR 002725J. You're charged with criminal trespass and damage to property. You understand where's Mr. Fleming?
Hold on, Judge. Me, Ryan. What's the name? What's this? Ryan. Yeah. Victoria. Tori. Tori. Come on. See you. How you doing, Daddy?
All right, thank you, Mr. Fleming. Do you understand your rights today? You're charged with criminal trespass and damage to property in this case.
What? Yes, ma'am.
All right, thank you, Ms. Sauer.
Yes, Your Honor, he has 35 cycles total. There is an open case, 26 SC, 000207 for robbery and simple battery. Currently on probation for case number 21 SC 179389, possession of methamphetamine with intent to distribute. Also on probation for case number 21 SC 179438 for manufacture, deliver, distribute, or possess with intent to distribute controlled substance in Schedule 1 or 2, possession of a firearm or knife during commission, cruelty to children, third degree, battery, receipt, possess, or transport of a firearm. There's a 2019 conviction for possession of marijuana with intent to distribute and willful obstruction of law enforcement officers. An open case out of the city of Atlanta for driving while license suspended or revoked and possess and use of drug-related objects. A 2017 conviction out of Fulton for unlawful manufacture, distribution, possess with intent to distribute imitation controlled substances. There's a 2024 FTA out of Fulton, three 2024 FTAs out of Fulton, a 2017 out of Fulton, 2016 out of Fulton, and a 2015 from the city of Atlanta. And then there's a 2013 conviction. The recommended level is level 3. There's also more history. He's currently also on probation for case number 25 SC 001786, possession of dangerous drugs and willful obstruction of law enforcement officers. On probation for possession of marijuana with intent to distribute and pedestrian failure to obey traffic. There's a 2024 conviction, battery, family violence, and cruelty to children, third degree. A 2017 possession of marijuana with intent to distribute and obstruction of law enforcement officers. Another 2017 VGCSA, possession of cocaine with intent to distribute, sale, distribution, and possession of dangerous drugs. VGCSA, drugs not in original container. And there's a 2016 criminal trespass, and then 215 convictions. Nothing further.
Thank you. Ms. Tucker?
Yes, Judge, we're asking for a $1,500 good bond with conditions no further contact with Shankisha Greer and to stay away from 3450 Forest Park Road in Atlanta. The facts allege that the defendant came to the victim's home to pick up their child, but the defendant sent the child upstairs to grab some clothes before leaving. Before the child had left, the defendant became angry, was banging on the door and the doorbell camera, causing damage to it. We did speak with Miss Greer. She confirmed the events in the warrant. She did say her children were present for the situation. Her son was leaving the home in the morning. She called his dad for help. She told her son to take everything that his father had bought and not take anything that she had bought, which is what led to the incident. She hasn't dealt with this defendant in this way in decades, but he can be an angry person.
Okay.
The ring camera is back on the door, but he was banging and saying stuff like scary ass hoe, what the fuck is wrong with you, called her a crackhead. They do not have a good parenting relationship. and he told his son that he was going to get some girls to jump on this victim on the bus. So she's requesting, she wants a signature bond, but you heard that history. 3 FTAs out of 2024. In addition to all those probations, I noted 2 probation violation arrests in 2025, one in 2024. So I cannot possibly recommend a signature bond. She does want no further contact with herself and no further violent contact with the son, and she wants him to stay away from this house. She did indicate that she'd be on Zoom and would like to speak, but just to recap, the state is requesting a $1,500 good bond, no further contact, and a stay away.
All right, Ms. Greer, if you're present, please turn on your camera and raise your right hand.
I'm here. It won't let me turn on my camera.
All right, there you are. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do.
All right, you can put your hand down. What would you like to tell me?
I do not request a signature bond. I request the highest bond. And also, just like she said, I just request him to stay away and don't come here being violent because he doesn't have that right at all. And I request the highest bond because of the simple fact of his history. He is very dangerous. He does not care. We can go years without talking. He still will approach me that way. I don't approach him that way. So yes, I would like him to stay away. And the highest bond also because he does not help me with my child. So he should have the money to give for the highest bond. That's all I have to say.
I appreciate you coming to court to make that statement, Ms. Kim.
Yes, Your Honor, my client is 32 years old, and Your Honor, we have no objection to stay away and no contact, Your Honor. And I believe that complaining witness and my client do not live together, and there's only one child together. And actually, was 13 years old child who called my client for the help because he was kicked out in the middle of the night. And he's only 13 years old and he had no place to go. And apparently there's a defect involved in this parenting situation with Miss Career. So there are open cases that my client want to make sure that his son is protected. That's all he wants. Your Honor, there is he completed GED after successfully completing GED. He has been working right now. He's not employed, but he worked for like temp services quite a bit. And Your Honor, we would like to request for signature on bond, and if Your Honor is not inclined to give him a signature on bond, I believe this is a Riverside issue because he was arrested on April 25, 2016 at the City of Atlanta ACDC. He was there for like 3 or 4 days and then got transferred here. So last 1, 2, 3, 4, he did not have any chance to have any first appearance. So I think this should be Riverside.
Can we check and see when he let me look myself. I have that he was only in jail for 2 days. So Ms. Kim, you're saying he was taken to ACDC before that?
He was at City of Atlanta and then he got transferred here 2 days ago. Apparently there was a traffic violation, but these are not the ones that kept him at the jail. Only reason that he was arrested and stayed at the jail was for him to be transferred to this location, Fulton County. I do have all kinds of papers that he was actually getting it from the City of Atlanta jail. That was April 25.
Okay, I'm looking.
Sure.
Miss Champion or Miss Bridgewater, can you also look for me? My thing is moving so slow.
I'm sorry, Your Honor. What is it that you guys need?
I'm just trying to figure out if this is a Riverside. I'm trying to figure out when he was booked in, and if anybody can see the other time.
Yes,
That- I'm not seeing that, Miss Kim. Miss Tucker, do you see this?
I'm looking at the booking documents. I haven't seen anything yet saying that he was booked before this.
Can like take a photo and then email out to Ms. Tucker, the other one. I'll be happy to do that. There was a traffic citation, but that did not help him at the jail. Okay, let me send this out too. It should be coming in very soon.
Okay. All right, I'm not seeing an indication of the Riverside. So until then, we're going to keep moving only because the calendar. If we get information regarding it in a moment, we'll keep going. Everyone, please still keep looking for me. Defendant's going to receive a $1,500 surety bond. He's to have no contact with Ms. Greer. Stay away from that location. Have no alcohol, drugs, or weapons. Of course, that is pending any information that we're forced to make changes due to Riverside.
Hey, Your Honor, may I ask you a question?
I don't think you should, but why don't you ask Miss Kim?
Yeah.
Don't contact none of my people about your child no more. I don't want to hear it.
We will worry about it.
I don't want to contact us about no bad. Stay away from it.
All right. For now, we're going to place Mr. Fleming on hold, but the surety bond will stand pending any other information. All right. Who do we have next?
Number 5, Ms. Cargill.
I'm sorry, number 5.
Yes, Ms. Cargill.
All right. Ms. Cargill, your case is 26 CR 002735G. You're charged with battery, family violence. You understand your rights?
I'm gonna take it out. Yes.
All right. Thank you, Ms. Stallworth.
Okay.
Your Honor, no prior history, recommended UJR jail.
Thank you, Ms. Tucker.
Yes, Judge. I did not have the time to fill out a consent bond. We got word from the victim too late, but we would be fine with a $2,000 signature bond through level 1 with conditions no further violent contact with Marlon Carmel. We did speak with him. He said they still live together, but they're trying to get separated. He's not afraid to be around her, but he wants her out as soon as possible. And I believe that is going to happen in about a month. So we're not asking for a stay away from this location at the time, but they are trying to move away. If we could also have a social worker visit for her, he did indicate to us that there are some MH issues, and he believes that might have been what caused this incident.
Okay. But I'm sorry. Ms. Kim, this is your client?
Yes, Your Honor. We do not
And
have
you and no objection to that? All right. I'm when social workers, I'm not going to hold her based on that, but Mr. Camille, if you'd like to make a statement, please unmute and raise your right hand. Realizing that she's getting released with a signature bond, so you probably shouldn't say too much. You swear or affirm the testimony against Debbie the truth to the best of your knowledge?
Yes, Your Honor.
All right. What would you like to tell me?
Your Honor, I'm here in full support of Ryan Delane Cargile. I respectfully request release on her own recognizance or in the alternative an unsecured judicial bond as the least restrictive condition sufficient to ensure her appearance. I also understand the charging decision rests with the state, but I do not wish to pursue prosecution, and I would support dismissal if the state deems it appropriate. Ryan is a very kind-hearted, hardworking, passionate, God-fearing woman. She has no violent past or record. And she has been dealing with financial hardship and significant stress. And being held is only making her situation that much more unstable. She does not have, or she does have family support available, and there is a safe place for her to stay after release. And she's entirely capable of complying with all court conditions. My goal here is just to support Ryan being released to a stable environment so she can move forward appropriately and handle this situation responsibly with family and people who care about her. So if we could, I understand that they're saying this, they want to go with the signature bond, but I'm requesting that she's released on her own recognizance.
All right. So Ms. Kim, you did consent to that. So defendant's going to receive a $2,000 signature bond at level 1 through pretrial services. She's to have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing further from defense, Your Honor.
All right. We're allowing this defendant to sign her own bond. Best of luck to all parties concerned in this case. Who do we have next?
16, Mr. Fundy.
All right, Mr. Fundy, your case is 26 CR 002742G. You're charged with battery, family violence. You understand your rights?
Yes, ma'am.
All right, thank you. Ms. Stallworth.
Yes, Your Honor. He has 14 prior adult arrests. There's an active warrant out of Bryan County, Georgia for a probation violation. Date of that warrant is April the 1st of 2022. There's a 2026 NOLO from the city of Atlanta for knowingly driving motor vehicle on suspended, canceled, or revoked registration. He's currently on probation out of DeKalb County for aggravated assault, criminal trespass, possession of firearm or knife during commission, pointing or aiming gun or pistol at another, battery, family violence, first offense, and receipt, possess, or transport a firearm. There's a 2018 FTA out of Coweta County. He's also on probation out of Coweta County for theft by taking and street gang participation. There's a 2019 conviction out of Coweta for willful obstruction of law enforcement officers, a 2017 conviction from Rockdale County for burglary, second degree, and fleeing or attempting to elude, a 2015 conviction out of DeKalb for simple assault, family violence, and a 2016 conviction out of DeKalb for driving without valid license. The recommended level is level 3.
All right, thank you so much. Ms. Tucker.
Yes, Judge. We're asking for a $5,000 good bond on this battery, family violence with conditions no further contact with Tanisha Phillip and to stay away from 325 Point Drive in Atlanta. You did hear he has a 2023 conviction out of DeKalb for aggravated assault and battery, family violence. So we are looking to upgrade this once we get more information from DeKalb. The facts of this case allege that when the victim arrived home, she saw her child's father, the defendant, his car in the parking lot. She exited her vehicle but left her child in the car because she was afraid. The defendant did approach and try to speak with her. She told him there's a court order for him not to have contact with her. So I believe that 2023 DeKalb case might be against her. I do not know for sure, but she did tell him there's a court order for him not to have contact with her, and he got upset about that and threw a hard black object aimed at her head. It missed her face, but it hit her arm, causing bruising and swelling. We did speak with her. She did confirm the events in the incident report. They are co-parenting. She said prior incidents were in Fulton, and that he's living in a transitional home, not this location. So we are asking for a $5,000 good bond, no further contact with Miss Phillip, and to stay away from this location.
All right, is Ms. Phillip present and wishes to make a statement? All right, hearing none, Ms. Kim.
Yes, Your Honor. My client, actually, his last name is Paul, and his first name is Brandy, so they are kind of swapped over. Anyway, Mr. Paul is actually, he was hoping to have a no further violent contact. However, he has no objection. He just needs to have a third party transfer for that child they share together. So he does have only one child, which is with completing witness. And after completing GED, he also got associate degree from Ashley University, and he did have communication and business management associate degree. And Your Honor, last for 2 months, he was not able to have any job, but he is enrolled in CDL school to start working as a truck driver next month. And we hope that he gets a signature on bond. If Your Honor like to give him a signature on bond, we ask for $1,000 surety bond. Yeah.
All right, defendant's going to receive a $2,000 surety bond. He's to have no contact with the alleged victim, stay away from that location, and he is going to our state purpose on the 12th. Is there anything additional?
Nothing further from defense, Your Honor.
All right, best of luck to you, sir. That concludes your case for today. Who do we have next?
20, Mr. Graham.
I'm sorry, I couldn't hear the number.
20.
20, thank you. Mr. Graham, Mr. Graham, your case is 26 CR 002703L. You're charged with battery and theft by taking. You understand your rights?
I do.
All right, thank you. Ms. Stallworth.
He has 14 cycles total, one from the state of Florida. He's currently on probation out of Clayton County for DUI. There are 3 open cases: City of Atlanta driving while license suspended or revoked, out of Cobb County for DUI, and out of Henry County for theft by deception. There's a 2021 conviction out of Cobb County for disorderly conduct, a 2023 conviction out of DeKalb County for criminal trespass, disorderly conduct, and willful obstruction of law enforcement officers. And there are 3 convictions outside of the 10-year period. One is battery out of Clayton, a battery out of Duval County, Florida, and a burglary out of Fulton. The recommended level is level 3.
All right, thank you. Ms. Tucker.
Yes, Judge, we're asking for a $2,000 good bond on the battery and a $1,500 good bond on the theft by taking, totaling $3,500, with conditions no further contact with Franklin Maldonado, and to stay away from 308 Maple Street in Hapeville. The defendant showed up at his friend's house, the victim's house, to shower, but he started acting weird, so the victim asked him to leave. In response to this, the defendant became defensive, started fighting him, grabbed his face, and threw him to the ground, leaving an abrasion on his right cheek. He then took his rifle and the key fob to his car and left. The rifle was found outside the house by the trash can, so it didn't leave the property, but he never got that key fob back. So we are asking, considering the history, you already's got 3 open cases, so he's out on bond for 3 cases, can't, not reoffend. We're asking for that $3,500 total good bond, no further contact, and to stay away.
Okay. Thank you. Let me first down. Is Mr. Maldonado present? We'll just make a statement. All right, hearing none, Ms. McCall.
Yes, Your Honor. I am asking for signature bond for my client, Your Honor. He is at the moment not in a position to pay for bond. This incident apparently happened some time ago, certainly several months. And just based on what my client tells me, there's a little bit more to the story than what was being said. They are friends, and my client denies that he took the key fob and all of that was being said. But there is a bit more to the story. They're not just friends, Your Honor. There is a bit of a relationship history there. So I'm asking for a signature bond for my client so he can get out of jail, Your Honor.
All right, defendant is going to receive $1,500 surety bond, 1,000 on count 1, 500 on count 2. He's to stay away from the address on Maple Street, have absolutely no contact with Mr. Maldonado. He's to have no alcohol, no drugs, weapons, and the matter will be reset to May 12th, state all purpose.
Is there anything additional? All right, best of luck.
Nothing, Your Honor.
All right, who do we have next?
Number 23, Mr. Johnson.
All right, good afternoon, Mr. Johnson. Your case is 26 CR 2727F. In this matter, you're charged with battery family violence. Do you understand your rights? All right, Ms. Stallworth.
There are 5 cycles from the state of Florida. There's 2 convictions outside of the 10-year period, a 96 ag assault with a firearm and an 82 traffic offense. The last date of arrest was 1998 out of Jacksonville, Florida for a probation violation. The recommended level is level 1.
All right, thank you. Ms. Tucker?
Yes, Judge. We weren't able to speak with this victim, so I did not prepare a consent bond order. But considering all of his histories prior to 1998, we would be fine with the $2,500 signature bond through level 1, with conditions no further contact with Jerry Ross and to stay away from 55 Far Road in Atlanta. The facts allege these parties were living together in an intimate relationship, and on this date, the victim asked him to leave. The defendant slapped him in the face, leaving redness on his cheek.
All right, is Mr. Ross present? Hearing none, Ms. Kim, any objection to the signature bond, which I'm inclined to grant?
No objection, Your Honor.
All right, defendant's gonna receive a $2,500 signature bond at level 1 through pretrial services. He said no contact with Mr. Ross, stay away from that location, have no alcohol, drugs, weapons. Is there anything additional? All right, best of luck to you, Mr. Johnson.
28, Mr. Murray.
All right, good afternoon, Mr. Murray. Your case is 26 CR 2716H. You're charged with 1 count of battery family violence and 1 count of simple battery family violence. Do you understand your rights?
Yeah.
All right, Ms. Stallworth.
He has 2 cycles total. There's an open case, 25 SC 007382 for aggravated assault. The recommended level is level 2.
All right, thank you. All right, Mr. Sirocco.
Yes, Your Honor. This incident took place, this was just April 28th, 2026. So yesterday at 201 Maury Avenue in Atlanta, officers responded to a fight call with injuries and made contact with the victim here, Miss Kanija Smith. She explained that the defendant, who is the father of her 2 children, had come to the residence unannounced, began banging on the door. He had entered the residence, at which time an argument ensued about him picking up their son. During the verbal altercation, the defendant grabbed her and struck her in the face multiple times. She didn't have swelling to her face as she believed she did, at least from the officer's observations, but they did see a visible abrasion to the right side of her neck that she believes she sustained during the physical altercation from the defendant. She also reported a wrist injury during her struggle with the defendant. Officers did speak with the defendant, who admitted that a physical altercation ensued when he went to go pick up his child. The open case, Your Honor, that it's really an aggravated assault, family violence, strangulation that's been, it appears to be on hold for pretrial intervention, but that was also against the same victim as here, Judge. And that was for essentially strangling her in 2024. He's in violation of the no further contact condition of his bond in that case. He received no further violent condition, along with third-party transport having been allowed. He doesn't appear to have abided by the third-party transport restriction here, and did violate no further contact with the victim. with the open aggravated assault strangulation case against the same victim. And with this taking place just yesterday, we are recommending a $7,500 surety out of the risk of danger to the victim here, risk of committing a felony prior to trial, and risk of reoffense. We are on that breakdown recommending $5,000 on the battery family violence, $2,500 on the simple battery family violence. No further contact with Kanijah Smith. Stay away from 201 Maury Avenue, Southwest in Atlanta. And no drugs, weapons, or alcohol while out on bond. I do believe I see her on the line. If we could sound for Miss Smith at this time, Judge.
All right, Ms. Smith, if you'd like to make a statement, please turn on your camera and unmute.
Hey, it say I can't turn my camera on.
You must have been doing something that they had to turn it off. You should be able to try now.
Okay.
All right, please, we need to be able to see. Please raise your right hand. Do you swear or affirm the testimony you give today be true to your best of your knowledge?
Yes.
All right, what would you like to tell me?
I would just want court to stay away from me and my children. I'm currently pregnant with his child, and he's still been putting his hands on me. So I just want the highest bond ever, and for him to have no contact with me.
All right, thank you. Ms. Kim?
Your Honor, my client is only 20 years young. After 11th grade, he has been working on his GED. He used to work for UPS, and however, nowadays he's working for his grandfather, doing auto mechanic, Your Honor. He's still qualified for public defender services, Your Honor. My client has no objection to stay away and no contact. And my client denies the allegations, and there was a scratch on her neck. Was she was jumped by somebody else? That person who jumped on her actually put the video on the Twitter, Instagram, and all that stuff. That video will clearly prove that my client had nothing to do with any altercation or marks on her body. My client is not, he does not have any violent or contact with her, Your Honor. And we ask for signature on bond. If Your Honor is not inclined to give him a signature on bond because of 25 SC case, we ask for $1,000 surety bond, Your Honor.
All right, defendant is going to receive a $5,000 surety bond, $4,500 on count one, $500 on count two. He's to have no contact with the alleged victim. Stay away from that location. Have no alcohol, no drugs, no weapons, and he's going to state all purpose on May the 12th. Is there anything additional?
Nothing further from defense, Your Honor.
All right, best of luck, to you, sir. Who do we have next?
34, Mr. Stevens. Thank you, Your Honor.
All right, Mr. Stevens, good afternoon. Your case is 26CR002696D. You're charged with 2 counts of simple battery family violence. You
This is
understand your
the-
rights today?
Sorry.
Yeah.
The dual arrest case, Judge, with Kevin Williams. I want to clarify with defense. I believe we have a signed consent bond for Mr. Williams,
But not for Mr. Stevens.
it's not clear. It sounded like he consented, but this was back when PD Kim had spoken with him before this was to be Miss McLeod's client, I believe.
That's the wrong case. This is 34, Thomas Stevens, right? Yes.
Oh, we're talking Thomas Stevens. Okay, my
Okay, I'm
apologies.
sorry. I called the wrong one. So, Mr. Thomas Stevens, your case is 26CR002697A. In this case, you're charged with simple battery. You understand your rights?
Yes, ma'am.
All right, thank you, Ms. Sauer.
There are 6 cycles total, 1 from the state of Maryland, 1 from the state of Alabama. There's an open case 25 SC 000157 for criminal damage to property, 2nd degree. Another open case 25 PI 005647 terroristic threats and acts. And then there's an open pretrial case 25 CR 003981J. I'll waive the sounding of the charge. It will be a bond surrender. And then there's a 2025 FTA out of Fulton, a 2021 conviction for DUI out of Fulton, and an 87 conviction from Maryland. The recommended level is level 3.
Thank you. Mr. Sirocco?
Yes, Your Honor. This incident here took place April 26th. 2026 at 53 14th Street in Atlanta. It's I believe, a hotel bar. I don't have the name of the hotel, but the officer made contact upon arrival with the victim, Mr. Jonathan Ware. He did state that he wished to press charges, reporting that he had been attacked by the white male at the bar. That individual, later identified as a defendant, had been pushing him, calling him names, using racial slurs, and punched him several times in the arm. The defendant, still on scene. He was on the floor, and he had blood on his face. A witness on scene, Ms. Dakara Curry, provided a statement that the defendant had been calling her names, using racial slurs towards her, and explained that the defendant's behavior was erratic, switching between affection and derogatory comments and verbal insults. With the open cases the defendant has here, felony terroristic threats and acts in Fulton, the open battery of a certain nature at Fulton, that's in state court, and then the other open case for criminal damage to property in the second, as well as his other history. We are recommending that the $3,000 bond, it's a surety that was imposed by the magistrate. We ask that that remains set. No further contact with Jonathan Ware. Stay away from the 53 14th Street Atlanta address, and no drugs, weapons, or alcohol while out on bond.
All right, is Jonathan Ware present, wishes to make a statement? All right, Ms. Kim?
Yes, Mr. Stevens is 64 years old and he has been here in Georgia on and off more than 9 years, Your Honor. And actually from January 2026, he has been struggling with residential challenges. And as you can see, his face, his right eye is totally black and blue. He was punched. And actually, in this case, he claims that he was a victim. And Your Honor, after getting an associate degree for communication, he actually worked at company for 45 years. However, he retired recently. And he also served for the country from 1981 to 1983 as a Marine Corps. Your Honor, he does have a very bad lower back pain. He does need to go take care of that. There's a medical needs for that. We would like to request for a signature on bond. And if Your Honor is not inclined to give him a signature on bond because of the current open cases, we ask for the lowest possible bond, $1,000 surety bond. Thanks.
All right, defendant's going to receive a $1,500 surety bond. He's to have no contact with Jonathan Ware, stay away from that location, and have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing further from defense, Your Honor.
All right.
All right, let's have 37, Mr. Towns. 37.
Mr. Towns, your case is 26 CR 002713A. You're charged with 2 counts of battery, 2 counts of simple battery, and 1 count of theft by taking. Do you understand rights?
Yes, ma'am.
All right, Ms. Stallworth, please.
There's one cycle from the state of Louisiana. The last date of arrest was December the 1st of 2022 from St. Charles, Louisiana. False certificates, tail lamps, and owner to secure registration. The recommended level is UJR jail.
Okay, thank you. Mr. Sirocco?
Yes, Your Honor. This was a September 30th incident from 2024 at 2166 Larchwood Road in Atlanta. Officers spoke with the caller and victim at that time, Ms. Desiree Devine. She explained that the defendant, her ex-boyfriend, had parked his car at her residence. It had been parked there since July 1st of that year. And she went to the defendant's house to pick him up, take him to where the car was outside her residence, because he also had tools and did not want to get on the bus with everything. After picking him up, the defendant had they went back to that vehicle where the defendant started working on it. He wanted to go to a grocery store. She told him she didn't feel like going. He could take her car. Wasn't enough fuel. He began to curse at her after she told him she would give him gas money. The defendant became even more upset and tried to enter her home. She had asked him to back up, leave her property. She ended up calling 911 as she didn't feel safe. He ultimately snatched tools from her hands and got upset that she had dropped his tools. In the process of that, began to threaten her by saying that he was going to slice her neck and beat her up. This was recorded at the time. However, the defendant had snatched her phone from her hands and left. She had confronted him, told him he couldn't take her property and that she wanted it back. At that time, he took a tool, some type of tool in his hand, and pressed it into her head. There was a bruise observed from that on her forehead, and she was pushed by the defendant, what looks like multiple times, causing her to fall down. And she had visible bruising to her elbow as well from that. The phone was worth $700. She provided receipts for that. And also, he had apparently reportedly grabbed a different tool and began to hit her vehicle on the front right door, though there was no damage. The victim, we were able to speak with Miss Devine. She explained that she had met the defendant while at work. He was interested in dating, so she gave him a chance after around 6 months and found the defendant to be a jealous person. He'd be agitated when she greeted people in stores. And after 2 months of dating, she was preparing for a cruise when she and the defendant got into an argument, this being a different incident, leading him to choke her in the middle of the night while she was asleep. She didn't report the altercation due to her leaving for her cruise the next morning. She requested the defendant leave the location due to his hostility, and shortly after, his vehicle broke down at her complex. She was trying to help him out here, and he's got some issues, potentially MH, and she, excuse me, that phone. Oh, excuse me. She was trying to record his behavior, and it sounds like she did so in the during this altercation. But he has made several threatening statements towards her. She has since gotten a TPO and moved. She is requesting no further contact, and that a stay away is not necessary because she doesn't. We don't want the defendant to know where she lives, and neither does she. The state's recommendation is a $4,000 surety, 1,000 on each battery, 500 on the simple battery and theft by taking each. We are requesting no further contact with Desiree Devine, no drugs, weapons, or alcohol while out on bond, and if she is online and wishes to speak, if we could sound for her, Your Honor.
All right, is Miss Devine present, wishes to make a statement? All right, Miss Kim?
Yes, Your Honor. Mr. Town is 31 years old and he was born in New Jersey. He resided here in Georgia for the last 24 years. And right now he's actually expecting a son very soon. He is about to be a father. He does have a bachelor's degree for public health and exercise science. Your Honor, my client was actually sous chef at the restaurant, but I believe because of this arrest, he may not have a job anymore. My client denies the allegation, Your Honor. This is his first arrest, and I interviewed him. I don't see any kind of MH issues or any kind of like something that is odd. He's very well-mannered, polite, and I don't think this incident actually happened. But September 30, 2024, which was almost 2 years ago, this was never addressed before. Your Honor, we asked for a signature on bond. He is recommended for UJR jail after all. We have no objection to stay away and no contact. That's all. Thank you.
Right. In light of the age of this case, and is this offense date correct,
Mr. Sirocco?
September 30th, 2024, Judge.
2024. All right. Defendant's going to receive a $5,000 signature bond at level 1 through pretrial services. It'll be 1,000, or it is 5 counts. 1, 2, 3, 4. It'll be 1,000 on each count. He's to have no contact with the alleged victim. Stay away from that location. Have no alcohol, no drugs, no weapons. The case will be reset for the notice. Is there anything additional?
Nothing further from defense. Thank you, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Number 11, Mr. Davis.
All right, Mr. Davis, your case is 26 CR 002714K. You're charged with battery, family violence, cruelty to children in the third, and obstruction. Do you understand your rights?
No.
All right, Ms. Stallworth.
Yes, Your Honor. I don't have the number of cycles, my apologies, but he does have an open pretrial case, 25 CR 006533K, battery, family violence, first offense, and driving while license suspended or revoked, and it will be a bond surrendered. And if you give me a moment, I will find the number of cycles. I didn't write it down. There's one prior arrest. Nothing further.
All right, thank you, Ms.
It's
Tucker.
that open case. You're welcome.
Thank you, Ms. Tucker.
Yes, Judge, you did hear that he has that open case that is battery family violence against this same victim. He was granted a $3,000 signature bond level 1 in that case by Judge Morrow. We are asking in this case for a $3,000 cash bond on the battery family violence and a $1,500 good bond on the cruelty, a $1,000 good bond on the obstruction, for a total $5,500 split bond, a no further contact with victim Carlicia Barlow, and to stay away from 1903 Akron Drive in Atlanta. The facts allege that after arguing, that the defendant and the victim were arguing after the victim's family was over. This led to the defendant striking her in the face and arms, leaving her with abrasions and bleeding. The defendant fled the scene after she called 911. Officers found him a few houses down, and he refused to identify himself or give any information about what happened. That's the basis of the obstruction. And this all occurred, the striking occurred in front of their 2-month-old son. We did speak with the victim. She did confirm the events in the warrant. They were arguing about him taking the baby. He's not supposed to come by the house himself to see the baby per the bond order in the previous case. His family was supposed to be him. So she put him out and he climbed back in through a window. He took her keys and phone. He was assaulting her when the police pulled up, and then he fled. They're not together anymore. He has had contact with her since the incident, mostly in the other case, mostly by phone, and then when he came over here. So she wants to get a TPO. She wants to move to be away from him. Even after all this, he called her this morning from the jail, clearly violating his bond. And she wants no further contact with him. She wants to stay away. She does not want him around. She does not want him to have any contact with the child unless he goes through the proper court. He's not legitimated. And so, and she wants a cash bond. So between, him obstructing, fleeing from the police when they were called, as well as he's proven that he cannot comply with the bond orders in the previous case, we're asking for that split bond, $3,000 cash on the battery family violence, $1,500 on the cruelty, $1,000 good on the obstruction, and no further contact and stay away.
And it was Carlicia Barlow.
Correct.
All right. Is Ms. Barlow present and wishes to make a statement? All right. Hearing none, Mr. Chataya.
Thank you, Your Honor. Mr. Davis is 22 years old. He's lived in Atlanta for the past 3 years now. He lives with his brother. He told me that he's on his way to graduation. His graduation is scheduled for May 9th. He's graduating from Atlanta Technical College in welding. For the past couple of months, he has worked at a temp service doing general labor. He requests the lowest bond amount possible, Your Honor. And if the court is inclined to give stay away order, I have no objection.
All right. Well, okay, sorry. All right, defendant's gonna receive a $5,500 surety bond, 4,000 on the battery and family violence, 1,000 on cruelty to children in the third, and 500 on the obstruction. He's to have no contact with the alleged victim, stay away from that location, have no alcohol, no drugs, no weapons. He'll be reset to state all purpose on the 12th. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Mr. Davis. Who do we have next?
Number 12,
I'm sorry, I'm not phone, the Zoom went out. What was the name?
12, Dunlap.
Thank you. Mr. Dunlap, your case is 26 CR 2712J. You're charged with battery family violence. You understand your rights?
Yes, ma'am.
All right, thank you. Ms. Stallworth?
Mr. Dunlap has 8 cycles total. There's an open case 25 SC 006106, purchase, possession, manufacture, distribution, or sale of marijuana and possession of a firearm during commission. There's a 2019 conviction from Fulton for theft by taking and simple battery. There's a 2017 NOLO from the city of Atlanta, possession of marijuana less than an ounce, and a 2017 FTA out of Fulton. The recommended level is level 3.
All right, thank you. Ms. Tucker?
Yes, Judge. I did submit a consent bond in this case. Were the PDs able to review it?
Yes, we were. He did consent to it. I thought I sent it over to Miss Bridgewater. I'm not sure if I did.
All
Ms.
right,
Bridgewater, did you get it?
so it is a consent. We can still put it on the record.
Yeah, put it on the record. I have so much paperwork here. I'm buried. So
All right. Well, let's we heard the history. So Ms. Tucker, let's put the recommendation on.
Yes, the recommendation is a $2,500 signature bond through pretrial level 1, no further violent contact with Samaya Handspike, and to go ahead and enroll in the Family Violence Intervention Program.
And I saw Ms. Handspike earlier. Ms. Handspike, if you wish to make a statement, please unmute, raise your right hand. Statements are not required. We are releasing this party on a signature bond as consented to with no further violent contact. Are you Ms. Handspike?
Yes.
Please raise your right hand. Do you swear or affirm the testimony you give today be true to the best of your knowledge?
Really?
All right. What would you like to tell me?
I just wanted to say that me and Thomas, we have been together for going on 4 years. We do share an 8-month-old. He has never been violent towards me, put his hands on me or anything. I do ask for also the signature bond. He is a working man and he's the primary provider for our household. I currently don't work, so we will need him home.
All right. And Mr. Shataya, you did consent, so the defendant will be released on a signature bond through pretrial 2,500 with those conditions. Is there anything additional?
No, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Number 14, Mr. Evans. I do.
Mr. Evans, your case is 26 CR 002708J. You're charged with simple battery family violence. Do you understand your rights today?
Yes.
All right. Ms. Stallworth, may I have the history, please?
Yes, Your Honor. He has 11 cycles total. He's currently on probation, case number 24 CR 005887A, disorderly conduct. Also on probation, out of the city of Atlanta, for driving while license suspended or revoked. There's a 2022 conviction from Douglas County for false imprisonment, a 2017 conviction from Douglas County for driving while license suspended or revoked, and purchase, possess, manufacture, distribution, or sale of marijuana, a 2014 no law out of Douglasville, driving while license suspended or revoked, and a 2013 out of Cobb for DUI. There's a 2022 FTA out of Douglas County and a 2017 FTA out of Douglas County. Recommended level, level 3.
Okay, thank you. We're gonna take a very brief 2-minute hold, everyone. I wrote down the history, so we'll be ready to jump right back in. Hold 1 minute for 2 minutes. All right, many apologies. Thank you, Ms. Tucker. Please proceed.
Yes, Judge, you did hear that he's on probation for disorderly conduct that was reduced from battery family violence against this same victim. So he was ordered or sentenced to have no further violent contact with Miss Janice Robertson. In consideration of that, we're asking for a $4,000 good bond. The facts in this case allege that the defendant showed up at the same after hours establishment as the victim, tried to talk to her, but she tried to ignore him. So while she was dancing, he came up behind her and shoved her, knocking her to the ground. Based on that, based on the history, we're asking for a total $4,000 good bond with conditions no further contact with Janice Robertson and to stay away from this location at 323 Edgewood Avenue in Atlanta.
All right, thank you. Mr. Shataya?
Thank you, Your Honor. Mr. Evans is 37 years old. He's a lifelong resident of the Atlanta area. He's a high school graduate. Currently, he's a forklift operator. He's been at his current position for the past 1.5 years, but he's been a forklift operator for 13 years total. And he also picks up cases at the warehouse where he works. He doesn't object to a stay away, and he also wanted the court to know that he cares for his children. He has a 3-year-old and a 1-year-old. And with that, Your Honor, he asked for the lowest bond amount possible.
All right, defendant's going to receive a $3,000 surety bond. He's to have no contact with the alleged victim, stay away from that location, and have no alcohol, no drugs, no weapons. Is there anything additional?
No, Judge.
All right, best of luck to you, sir. Who do we have next?
Mr. Hawkins.
Mr. Hawkins, your case is 26CR002722C. You're charged with battery family violence. You understand, right?
Yes, ma'am.
Thank you, Ms. Sauer.
Yes, Your Honor, he has one prior arrest. The last date of arrest was November the 1st of 2020 out of Clayton County for battery. There's no disposition listed. The recommended level was UJR jail.
Thank you, Ms. Tucker.
Yes, Judge, I believe this was also a consent bond. The terms were, this is a $2,500 signature bond through pretrial services, level 1, for him to enroll in and complete the anger awareness course, to have no further contact with Aubrielle Clay Hawkins, and to stay away from 2223 Polar Rock Avenue in Atlanta.
All right, is Aubrielle Hawkins present, wants to make a statement?
This was a dual
Oh, a dual
arrest.
arrest.
Yes.
Understood. Thank you. So, Ms. Kim, do you so consent?
We consent everything except that that place is my client's house, and he does not live there, so he wants to be able to go back home, Your Honor.
All right, so what we'll do is he can return one time with law enforcement to make that determination. All right?
Yes, Your Honor.
All right. All right, who do we have next? Mr. Hawkins?
Your Honor, go over the bond amount again. I stepped away.
He's gonna receive a $2,500 signature bond at through pretrial level 1. He's gonna enroll in the, how many anger awareness was it, Ms. Tucker?
Just the 1-day anger awareness.
He's gonna do the 1-day anger awareness, have no contact, and he is to stay away if the victim is still there. They're gonna return with a law enforcement escort to make the determination.
Thank you.
All right, best of luck to you, Mr. Hawkins. You're being released on those terms. Who do we have next?
29, Mr. Ormsby.
All right, Mr. Ormsby, good afternoon. Your case is 26CR002692E. You're charged with criminal trespass. Do you understand your rights?
No.
All right, Ms. Stallworth.
He has 12 cycles from the state of Florida. There's an open case out of Miramar, Florida for cruelty towards child and firing weapon. There's an 06 conviction for disorderly conduct, and the recommended level is level 2.
All right, thank you. Mr. Sirocco?
Yes, Your Honor, this incident took place April 27th of this year, 510 Summerbrook Lane in Fairburn. Officers responded to a domestic dispute call. They made contact with the victim here, Miss Regine Brown. She is the domestic partner of the defendant. They got into an argument over the weekend, and the defendant left the residence. The defendant came back to the residence without her consent, retrieving his belongings, and before entering, he had ripped the Ring doorbell camera off of the front door. On that date, the 27th, she went to get an eviction notice, temporary protective order. She was able to provide footage of the defendant coming to the residence and pulling the Ring camera off the door before it lost power. They were living together at that address, the 510 Summerbrook Lane address, and the defendant, shortly after this report was made, had pulled into the driveway and was placed under arrest here. Miss Regine Brown, we have spoken with. The two had been together for 8 years, broke up last year. 2 small children they share, and the victim has 2 other children that lived with them. And the defendant lived there until Saturday, the 25th. He broke the door down, and police were called on the 25th also. The defendant, when he returned, that's when he was arrested on this charge here. They're no longer together, and she has filed a TPO, I believe, and an eviction as well. The defendant still needs to be served. She did confirm the events in the warrant here, and says the defendant's broken, a personal property of hers before, but has replaced it in the past. It wasn't as serious as it is now, and she's concerned with this being more serious now. She was granted that TPO, and the defendant was texting her, threatening to kill her. Oh, excuse me, because the defendant was texting her, threatening to kill her. She's received from the defendant threatening text messages, and those have been sent as well by the defendant to her family. The defendant's not been physically violent with her, but she is very scared, and police told her to go to her mother's house. She is seeking no contact with the defendant, a stay away order from the home, and she was hoping for a cash bond here as well. The state's recommendation on this, with the concern for the victim, as what's been reported, and also with that prior firing a weapon/missile into a dwelling, vehicle, or building. That was that 2018 case out of Florida. I'm not sure whether that case has been closed out or not, or what the disposition is there. As far as I'm concerned, that could be open. State's recommending a $2,500 surety, no further contact with Regine Brown, stay away from 510 Summerbrook Lane in Fairburn, and no drugs, weapons, or alcohol while out on bond.
All right, Ms. Brown, I did see you present. If you wish to make a statement very briefly, this is your opportunity. However, statements are not required. If you wish to speak, please unmute and raise your right hand.
Hi, Your Honor. My name is
All
Rachel.
right. All right. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
I do.
All right. Please proceed. What would you like to tell me?
At this time, again, like the gentleman had mentioned, I just, a TPO order has been, granted for me, as well as an eviction to our residence. He may have not been served. I had the address changed to where he's located now. I just want him to stay away from me at this time until the house gets sold. And that's all I recommend at this time.
Thank you. Ms. Kim, I appreciate you making that statement, Ms. Brown.
Yes, Your Honor. Mr. Ormsby is actually 38 years old and was born and raised here in Georgia. They do share two children, and that's the only children that he has. So he has no objection to stay away and no contact as long as he gets a third-party transfer to be able to spend time with his children, Your Honor. After graduating from high school 2006, he has been working at Cisco warehouse. And Your Honor, we would like to request for the lowest possible bond, $1,000 total bond. Thank you.
All right, thank you. Defendant is going to receive a $1,500 surety bond. He's to have no contact with Ms. Brown, stay away from that location, have no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right, Pastor, let's see, sir. Who do we have next?
31, Mr. Sugar. Sugar. Sorry.
Okay. Okay, good afternoon, Mr. Sugars, or is it Sugars? Your case is 26 CR 002694J. You're charged with 2 counts of obstruction. Do you understand your rights? All right, thank you, Ms. Dollar.
There are 4 cycles total. There's an open case, 25 CR 007694J, battery, family violence, first offense. There's an active warrant out of Fulton for a probation violation. Date of that warrant is November the 30th of 2025. He's currently on first offender probation for case number 24 SC 006468, aggravated assault, possession of firearm or knife during commission. And there is an open case out of DeKalb County for possession of firearm during commission and possession, manufacture, distribution, or sale of marijuana. The recommended level is level 3.
All right, thank you. Mr. Sirocco?
Yes, Your Honor, this was an April 27th incident at 100 Fulton Street in Atlanta. Officers were dispatched there in reference to a verbal dispute, and during the course of that investigation, the officer had made contact with the defendant, asked for his identification. They ran that information through their network, and it showed that he had an active warrant out of Fulton County Sheriff's Department. That appears to be for the probation violation for the Felony First Offender Act case 24 SC 006468. Officers returned to detain him, instructed him to place his hands behind his back. He didn't comply with either officer's verbal commands, turning, refusing to follow instructions, and continued resistance even inside the vehicle. Interestingly enough, that battery family violence case, the open one, 25 CR 007694, that was also at 100 Fulton Street Southeast in Atlanta. He is in violation of his stay away condition of his bond in returning to this location. The victim in that case is Akasha Irving. That's where she resides. Can't imagine who that verbal dispute was with, but a motion to revoke bond has been filed for that case. Currently, bond is set at a $2,000 surety. We're requesting it remain set. Stay away from 100 Fulton Street in Atlanta. No drugs, weapons, or alcohol while out on bond. And I believe that's all for this case, Judge.
All right, thank you. Ms. Kim?
Yes, Your Honor, because of probation violation, he will be here no matter what he gets for these two obstruction charges, Your Honor. So we ask for signature on bond or the lowest possible bond of like $1 cash bond. Your Honor, he is 21 years young. He does not have any child. After graduating from high school 2022, he's been working for a construction company and also Legal Shield, two jobs, working very hard. We ask for the lowest possible bond. Thank you, Your Honor.
All right, thank you. Defendant's gonna receive $1,000 surety bond, 500 on each count. I am gonna add that he needs to stay away from that location, have no alcohol, drugs, weapons. Is there anything additional?
No, Judge.
All right, best of luck to you, sir. Who do we have next?
33, Mr. Stevens.
Okay, Mr. Stevens, this is a case I called by mistake earlier that is a dual arrest. Okay, so Mr. Stevens, your case is 26 CR 002696D. You're charged with 2 counts of simple battery family violence.
May not be a consent bond. We have to clarify with the fence.
All right. Let's still hear the history. Miss Saworth?
Yes, Your Honor. He has 2 cycles total, one from the state of Tennessee. There's an open case out of Nashville for possession of casual exchange of controlled substances. There's an open case out of College Park for DUI. That arrest date was November the 6th of 2023. The recommended level was level 2.
Thank you. Mr.
Consent
Sarah?
bond.
There's a consent for this one?
Yes, Your Honor.
All right, Mrs. Straka, do you want to put the consent on? I'm sorry, you said the recommendation, Ms. Starworth, was level 4?
Level 2.
Level 2.
Yeah.
All right, Mrs. Straka?
Yes, Your Honor. The consent bond offered in this case is as follows: a $5,000 total signature bond through pretrial services. Level 1, we had the breakdown being 2,500 on each simple battery family violence charge. Defendant shall enroll in and complete 2 anger awareness classes through pretrial, have no further violent contact with Kevin Williams, the cross defendant here, shall have no drugs, alcohol, or weapons while out on bond, and have no further violations of the law as well. And I believe that is it. So this is your case, Miss Kim?
Yes, Your Honor. Yes. Oh, yeah, he accepts the bond.
And okay, so Mr. Stevens, you'll be released on a signature bond with those conditions.
Okay, thank you, Your Honor.
35, Ms. Thurman.
Okay, and this one was a dual arrest for number 49. And I don't remember, may have to refresh me on 49. Mr. Thurman, your case is 26 CR 002699H. You're charged with battery family violence in this case. You understand your rights?
Yes, ma'am.
Position number 49 was the cross, Miss Winfrey, I want to say.
Yes.
Okay, so this is the dual for this one.
Mhm.
Mr. Siracco?
Yes, Your Honor. This incident here, we don't have a consent bond here. We're recommending a surety. This was a April 27th incident. This was the MARTA Street, the MARTA West End Station.
Yeah, I
fight
remember
between
now.
them. Yeah, and they both had visible injuries.
Understood.
Right. I'm not sure if we want to hit pretrial, but from what I can see, I see a robbery by force and battery conviction from 2018, simple battery conviction 2017, FTAs from 2025, 23, 20, and 18, and also recent convictions for giving false information and obstruction, 2025, and giving false information and shoplifting, 2018, other shoplifting convictions, 2020, 2021. With that being said, the state's recommending a $1,500 surety, no further violent contact with Miss Regina Winfrey, no drugs, weapons, or alcohol while out on bond, and I believe that's all.
All right, is Regina Winfrey present? I'm sorry, that's a cross defendant. I'm sorry, I'm getting tired. All right, Miss Kim,
Yes,
please
Your
forgive me.
Honor. Yes, my client is 48 years old, Your Honor. He was born and raised here in Georgia, and he does not have any children together with complaining witness. They are legally married and they have been living together. So he wants to have a no further violent contact, Your Honor. And after 11th grade, he has been working at a temp company, but right now I believe he believes he lost his job. And also he has a congestive heart failure, so he has to take care of his medical needs. We ask for the lowest possible bond, preferably signature on bond no matter what level it is. If Your Honor is not inclined to give him a signature on bond, we ask for maximum $50 cash bond.
All right, defendant's gonna receive $1,000 surety bond. He's to have no further violent contact with the cross defendant, have no alcohol, no drugs, no weapons. And the case will be reset to May 12th. Is there anything additional?
No, Your Honor.
Nothing further.
All right, best of luck to you, Mr. Tutterman.
And this got 41, Mr. Ward.
All right, Mr. Ward, good afternoon. Your case is 26 CR 0027001C. In this case, you're charged with criminal trespass. You understand your rights today?
Yes, Your Honor.
All right, thank you. Ms. Stallworth? You're muted, Ms. Stallworth. I can't hear you.
Oops, my apologies. I'm sorry. There's 13 cycles total, 1 from Florida, 3 from California. There's an active warrant out of DeKalb County for a probation violation. Date of that warrant is February the 4th of 2026. He's currently on probation out of Cobb County for criminal trespass, willful obstruction of law enforcement officers, and criminal damage to property, 2nd degree. Also on first offender probation out of DeKalb for burglary, 2nd degree. There's an open case out of Dunwoody for financial transaction device, and an open case 25 SC 004315, burglary, 2nd degree, theft by taking and criminal trespass. There's a 2023 NOLO from Gwinnett County for willful obstruction of law enforcement officers. There's a 2023 FTA out of Dunwoody, a 2018 conviction out of California for trespassing, and another 2018 out of California for obstruction of public officer. The recommended level is level 3.
All right, thank you, Mrs. Sirocco.
Your Honor, the defendant here, this was on April 27th at the Lindbergh MARTA station, had gone wayside beyond the emergency gate of the south end of the platform into a restricted access area that was designated as such with signs. He gained access onto the train tracks there, causing an 8-minute delay in rail services. You heard the history here, criminal trespass, damage to property conviction, other convictions that are related, at least trespass-wise. And that open case, the ending in 4315, the burglary in the second case, that appears to be on judicial hold due to him failing to appear. And that he does appear to have that foreign county hold out of DeKalb for a probation violation. So with the risk of failing to appear and the risk of reoffense, as well as, I mean, we're concerned for his own safety. I mean, he could have been hit by a train doing something like this. We're requesting that the $1,500 surety bond that's currently set by the magistrate remain set. We'd request a social worker visit for BH and housing if appropriate. Stay away from MARTA in accordance with any active bans or suspensions, and no drugs, weapons, or alcohol while out on bond.
All right, thank you. Ms. Kim?
Yes, Your Honor. Mr. Ward is 29 years old, and this happened at Marta, and he's at a flight risk because he will be transferred to DeKalb County Jail, Your Honor. We ask for signature on bond or to be released to DeKalb County. for the lowest possible bond. He graduated from high school 2015. Right now, he does have two jobs. He's working at restaurant and also laundromat. He's trying to save money so he can go to study for film production, Your Honor. We ask for the lowest possible bond, and we will recommend him for social worker visit for housing resources as he has been struggling with his residency.
All right, defendant's gonna receive $1,000 surety bond. He is to stay away from murder and comply with any suspensions. He's to have no alcohol, drugs, or weapons. Best of luck to you, sir. That concludes your case for today. Who do we have next?
46, Mr. Kevin Jerome Williams.
All right, Mr. Williams, your case is 26 CR 002741J. You're charged with criminal trespass. Do you understand your rights? Thank you. Ms. Stallworth, may I have the history, please?
Your Honor, there are 13 cycles total, 11 from the state of Mississippi. He's currently on probation for case number 24 CR 004106D for reckless conduct. There's a 2020 FTA out of the state of Mississippi, and the recommended level is level 1.
All right. Mrs. Sirocco?
Yes, Your Honor. April 28th of this year at 4100 Wendell Drive in Atlanta, the USA Economy Lodge Motel. He had been issued a criminal trespass warning and returned to the property. He kept coming back to the property for no business. Footage was shown of the defendant entering the property, and he admitted as well he's entered the property several times. I saw as recent a conviction for reckless conduct, 24 CR 004106D, discharging a firearm through a closed door room of a Budgetel hotel. He may or may not still be on active probation for that. He was convicted in May of 2025. With his FTAs 2020, 2016, as well as minimal length of residence in the community, it doesn't appear he came here to Georgia until 2021. We're recommending $1,000 surety, social worker visit for housing, stay away from the USA Economy Lodge Motel at 4100 Wendell Drive, and also no drugs, weapons, or alcohol while out on bond.
I'm sorry, Mrs. Sirocco, what was the amount of your recommendation again?
$1,000 surety, Your Honor.
Okay. All right, thank you, Ms. Kim.
Yes, Your Honor. My client is 42 years old, and Your Honor, he has been here in Georgia for almost 8 years. He has 4 minor children. After 11th grade, he got GED, and then he also works as a cook. But he lost his job, and ever since his loss of job, he's been trying to find a job, but he could not. So that's why he's struggling with residential challenge. And we definitely will recommend him for a social worker so he can get housing resources, Your Honor. But we ask for a signature on bond. He does not have any funds to pay for any bond at this point. Thank you.
All right, defendant's gonna receive that $1,000 surety bond. He's gonna have to stay away from that location, no alcohol, no drugs, no weapons. Is there anything additional?
No, Your Honor.
All right, best of luck to you, sir. That concludes your case.
Yeah, 47, Kevin Lamar Williams.
There was a consent on that one.
Yes, he got consent bond, and he actually accepted the consent bond.
All right, Mr. Williams, your case is 26 CR 002695J. In this case, you're charged with 2 counts of battery family violence. Mr. Stallworth, will you very briefly put his history onto the record?
Yes, Your Honor. He has 1 prior arrest. He's currently on probation for case number 11 SC 104775 for a CWEC charge. The recommended level was level 2.
All right, Mrs. Sirocco, if you want to put the consent on.
Yes, Your Honor. On the 2 counts of battery family violence, state's recommending a total of $5,000 signature bond through pretrial services level 1. The breakdown being $2,500 each. The defendant shall enroll in and complete 2 anger awareness classes through pretrial services, shall have no further violent contact with DeMarcus Stevens, shall have no drugs, alcohol, or weapons while out on bond, and shall have no further violations of the law.
Okay, so Ms. Kim, your client so consents?
Yes, Your Honor.
All right, you'll be released on a signature bond with those terms, Mr. Williams.
Thank you, Your Honor.
All right, who do we have next?
Go to the waive cases, number, number 40, Miss Van Hydrick.
I'm sorry, Ms. Please there?
No, this is waive case.
This is waiver, Your Honor.
Okay, let's take up waive case position 4026 CR 2707J, in which defendant is charged with 2 counts of disorderly conduct and 1 count of obstruction, 1 count of criminal trespass. Ms. Stallworth?
Yes, Your Honor, 7 cycles total. Open case 25 CR 002111J, simple assault, battery, and criminal trespass. Another open case 24 CR 000554J, theft by taking. And another open case 22 CR 008312J for battery. There's a 2022 conviction for battery, family violence, first offense from Fulton, and a 2014 reckless conduct from Rockdale County. The recommended level was level 2.
All right, thank you, Ms. Tucker, or is it Mrs. Rocco?
This isn't my case, but I am very familiar with this defendant. She's been in the MHC. I'm texting Miss Melnick, the PD in the MHC, and she did let me know that this will have to be a conflict case, that the public defender does represent another defendant in which in another case in which Miss Van Hydrick is the victim.
Okay, so Ms. McLeod, did you have a chance to speak to Ms. Van Hydrick? I think I know Ms. Kim said there was a waiver, but if there's a conflict, I don't think Ms. Kim can waive.
Your Honor, I did not speak with her. I was unaware of the conflict, and she was not on the list that I received.
Okay, so it looks like we're gonna have to reset this case then to Friday's calendar, in light of the fact that she couldn't effectively waive. Ms. Taylor, you're here for this case. The case will be reset to Friday.
Yes, ma'am. I'm actually her mother.
All right.
And
Perhaps
I-
Ms.
I-
McLeod
I-
should. I
I
don't
have
want you to
just a-
say. Go ahead.
I just have a small thing that we truly do need to add as you move the case forward. And I actually agree that my daughter's arrest.
Okay.
My daughter,
I don't want you to say too much to me, Ms. Taylor. This isn't a recorded proceeding. You may accidentally say something that
I do
doesn't
understand.
help. All right. Ms. McLeod is more than likely going to be the defense attorney who is assisting your daughter. Ms. McLeod, is there some contact information you might be able to give to Ms. Taylor?
Yes, Your Honor. So I can text her my phone number in the chat.
All right, Ms. Taylor, Ms. McLeod is going to provide you with some information, and perhaps the information you want to express to the court, you can give to Ms. McLeod so she can best navigate how to assist. Okay?
I appreciate you. Thank you so
And
much.
yes, ma'am. I just don't want you to say. Sometimes things are said on the record and it
They're
turns
okay.
into something else, and we don't want that. Okay?
I appreciate you. They are aware. Thank you.
All right. So we're gonna take up Ms. Van Hydrick's case on Friday.
May 1st.
Oh, Friday, yes, ma'am. Friday, May 1st. But my question would be, I guess, Ms. McLeod, I don't know how you'll handle the waiver, but apparently she'll need to waive with you when you speak with her, if possible. All right?
Yes, Your Honor.
Thank you. Did we finish the entire calendar? No, we did not. Position 48, is that a reset?
No waiver, Your Honor.
Okay, let's take up waive case. Position 4826 CR 002711C, in which defendant is charged with 2 counts of simple battery family violence. And can I have that criminal history, please, Ms. Stallworth?
Yes, Your Honor. There's 1 prior arrest. There's a 2015 failure to maintain lane and reckless driving out of Fulton. The recommended level was level 1.
All right, thank you, Mr. Sirocco.
Yes, Your Honor. I'll make this quick. April 21st through the 22nd incident, 975 Piedmont Ave in Atlanta. Victim is the defendant's daughter. She is 18, Deja Wilmington, and there was an altercation starting on April 21st. Her father got mad about a few things, and essentially he placed his hands on her face and slapped her. He had a hat and hit her with that several times. And on April 22nd, there was another incident between the two where he placed his hands on her face again and slapped her twice on the right side of her face. She doesn't even know what, at the time at least, what she said to irritate him that time. The defendant was ultimately arrested here. We did speak with Miss Wilmington. She's a senior at North Atlanta High School. And it's just her and her dad at home, and she's lived with him since 2024. Her mother lives in Young Harris, Georgia, and her stepmom lives in Dallas, Georgia. She confirmed the events in the warrant. State's dad's never physically been violent with her before, but it feels like he's always irritated with her. And the number of things I do want to include that this was her dad had asked her to give educated answers to one of his questions. And in one of these incidents, Anne had balled up his fists and threatened to beat the F out of her if she did not. She's okay with having contact with father via phone, but not okay with him being around her in person. She's asking for a stay away from the new address in Dallas, 471 Ireland Lane. I don't believe she's on Zoom, but the state's recommendation with her statements regarding the threats, it does give us additional cause for concern. We're requesting a $2,000 total surety, 1,000 for each simple battery family violence. We would request one parenting class. No further in-person contact with Deja Wilmington, if that's permissible with the court, as well as stay away from 471 Ireland Lane in Dallas, Georgia. No drugs, weapons, or alcohol.
All right, thank you. Ms. Kim?
Your Honor, my client is 41 years old. We asked for signature on bond because the remote case from 2015, it was about traffic violation. There was no violence related case before. He has been here in Georgia for more than 30 years, and he does have 5 children. And this actually was not his daughter who called the police. It was ex-wife who was not even there, called the police and reported his daughter. My client denies the allegation, Your Honor. He believes that it was fabricated, and he graduated from high school, and also he went to Georgia State University for a bachelor's degree. He has a psychology major. He has been working at this school for more than 12 years. And Your Honor, right now he is also working as a fitness trainer, and he's a bodybuilder and life coach. Your Honor, we are asking for signature on bond, and because of the medical condition, he's got some surgeries on his back. That's the reason that he could not be here in person, because he does need to clean out the bones, which is so bloody. We ask for signature on bond. We have no objection to no contact as long as he can return to his place, 975 Piedmont Road. Thank you.
Okay, I'm sorry. The daughter is a senior in high school, Mrs. Sirocco, and lives only with the defendant.
She's since moved, Your Honor, to the
She's
Dallas,
moved.
Georgia address that I provided the court.
Okay, I just want to clarify, make sure I wasn't sending a child to live alone.
Right.
Okay, defendant is going to receive a $1,500 surety bond, 1,000 on count 1, 500 on count 2. He's have no contact for now with the alleged victim. I'm sure we can revisit that at a later date, and he can return to his location if the defendant has vacated. He can return one time with a member of law enforcement to make that determination. He's to have no, well, actually, Mrs. Rocco, you said that she has vacated, so we don't need to do the stay away.
Right.
He's to have no alcohol, drugs, weapons. So please delete the stay away, but it is no contact for now. Is there anything additional from State of Defense?
Can it be 10%, Sheriff's Remy Runner? He never had a violence history before.
Miss Stallworth, run me back. I'm sorry. Can you give me the history one more time? Getting tired. I said run me back.
That's okay. It was Wilmington, right? Come on.
Yes. Uh-huh.
I have a reckless driving, failure to maintain lane
Yeah,
conviction,
it was just a
2017.
2015.
Yeah. Okay.
And
We'll
that
let
is
him do the
DUI.
sheriff's 10%, Miss Kim. All right.
Or change to signature on bond, Your Honor. Because
He's got a F. He has he's not eligible. He has the one FTA. So, I guess he ends up going through pretrial anyway. Essentially, with the sheriff's 10%, he ends up getting monitored by pretrial and paying the small amount. We're gonna leave it. He can go through the sheriff's 10%. I'm gonna reduce it slightly. It'll be $1,000 surety bond, 500 on each count, and he's going through the sheriff's 10%. All right.
Thank you.
All right. Position 17, is that a reset?
That was a waiver, Judge.
Okay. All right, we're going to take up the waive case for number 1726 CR 002706Y. Defendant is charged in this case with criminal trespass. Ms. Stallworth?
3 cycles. There's a dormant case, 24 CR 000871Y, criminal trespass and willful obstruction of law enforcement officers. The recommended level is level 2.
Right, thank you. Ms. Tucker, mostly concerned with where she was and how many prior warnings, I guess.
Yes, she was at 1375 Wichita Drive in Atlanta. This is a private residence.
Very
And
famous residence, but yeah, go ahead.
okay, Mr. Thomas Howard, who's the property manager at this address, did say he saw the defendant earlier that day, told her she could not be there, and she was found sleeping in the garage.
Okay.
We're asking for $1,000 good bond and stay away.
All right, Mr. Shataya, I'm inclined to grant that. So does she also need a social worker? Sounds like there may be some housing concerns.
I asked her if she had a place to live, Judge, and she gave me an address. It's your discretion if you want to order a social worker visit, but she did give me the address of 1326 Wichita Drive as her home, and she told me that that's where she lives.
Okay. Okay. All right. Defendant is going to receive $1 cash bond. She's to stay away from that location, and she's to have no alcohol, drugs, or weapons, and she'll be reset in light of the dollar to the May 12th state all purpose. I wish she was here today so I can emphasize the importance of not going back to that location. So please share that with your client, Mr. Shataya.
Yes, Judge.
All right. Have we
Right.
Yes, ma'am.
What did we do with position 14?
I don't know.
Is that
I know. I'm
position
sorry.
15?
No, 14. 14.
Okay.
I don't have anything for 14.
Oh, I think 14 was a $3,000. Did I do surety? I just wrote $3,000.
Yes, it was a $3,000 good bond.
That's what I thought. Thank you.
Okay. All
And
right.
going back to 15, did we ever figure out if that was a Riverside?
Yeah, so I did receive some documents from Miss Kim. They did show that he was arrested in Atlanta on the 25th, and I think it's pretty likely that they held him and transferred him over here on the 28th. So, regrettably, I do believe this is Riverside. You granted a $1,500 good bond. I guess we gotta amend it to a UJR.
Yes, it'll be 1,500 signature bond through the jail with those same conditions.
Okay.
All right. Are there any other matters that we have not addressed before we can review the calendar?
Nope. We are all done here, Your Honor.
Okay, Ms. Bridgewater.
Yes, ma'am. You ain't got to tell me but once.
Oh, I'm sorry. Ms. McLeod has a
It's
question.
something that I need to put on the record, Your Honor.
Oh no, Miss McLeod.
would
Do
like
you,
to.
must you, Miss McLeod? Go ahead.
But I would like to, I think it's important. It concerns my client, Mr. Whitlaw. Uh, the alleged victim is a Theodosia Smith. And I believe I had mentioned when he was on that she was trying to call me. I did return her call, Your Honor. And I told her that she was asking about his bond and so on. So I explained to her that you had ordered no further contact, and she became very belligerent and told me that she was going to have contact with him because they had a child together. And when I told her that, that you had ordered otherwise, she essentially cussed me off, sent me a whole bunch of text messages that I had, calling me the F word and the B word and saying that,
Not a
nobody's
good
going to
day.
stop her from having contact with him. So I just wanted to let you know that she is actively going to sabotage my client's ability to stay away from her.
Just for the reiteration, this was he already has that open 26 PI 002351 case where he's ordered to stay away. Or no further contact, excuse me. So there is that. This
Oh,
bond order
right.
was
So,
Understand?
all right. Well, it'll stay as set, and
What
that.
she is saying to me here, Your Honor, she says she is going to be there when he gets out. She says, I don't know him. She's gonna get him out of jail again, B word, and it's me all here on my
Okay,
phone, these text
he
messages
might need
she
a new.
sent me.
Okay, that I don't. There's
Been a
not much I
long
can do
night for
about.
that, for her cutting up like this.
It's not a lot I can do about her, Miss McLeod. I do
She
know
kept
that, and
calling me, calling me back when I wouldn't talk to her.
all right. I do note this, but there's another case where it's already they can't. I mean, you need to advise your client that there's not even if we were to change this case, you Miss McLeod, the other case is still holding him in a no contact with her status. And I mean, perhaps is there a all right,
She's
Ms.
made it clear
Rocco,
to
is
me.
there a victim witness advocate that can perhaps speak to her and let
Yeah.
her know that she will do nothing but interfere with his
Freedom.
situation if she continues to act in that manner? And I wish she was here, Miss McLeod, because I would direct her to respect and comply with proper decorum and referring to you. It's my advice, as I gave this advice in an earlier court today, to please block her because you don't have any obligation to speak to her, nor do you have to accept any abuse. Okay, all right, everyone. We have limped to the end of the finish line. Are we ready to review the calendar? Are there any other matters that we should address before we review this calendar? And I do thank everyone for trying to do the consent bonds. It would be great if we could get them even earlier so we don't have to bring the people. But I do appreciate the number that were here today. Ms. Bridgewater, will you please take it away?
I'll take it away. Once again, the reset date for the SAP calendar is May 12th. Position number 1 is going to the SAP calendar with a $1,000 good bond. 2 is reset further notice with a total $15,000 SOB through pretrial per judge. 3 is a consent bond with a $1,500 SOB through pretrial. 4 is going to the SAP calendar with a $1,000 good bond. 5, reset further notice with a $2,000 SOB through pretrial. 6, SAP calendar with a $1,000 good bond. 7 is a consent bond with a total $2,000 SOB through pretrial. 8, reset further notice with a total $2,000 SOB through pretrial. 9 is going to the SAP calendar with a total $2,000 split bond. 10, reset further notice with a $2,000 SOB through pretrial. 11 is going to the SAP calendar with a total $5,500 good bond. 12 is a consent bond with a $2,500 SOB through pretrial. 13 is reset further notice with a total $2,000 SOB through pretrial. 14 is going to the SAP calendar with a $3,000 good bond. 15 is reset further notice with a $1,500 SOB through the jail. 16, SAP calendar $2,000 good bond. 17, SAP calendar with a $1 cash bond. 18 is a consent bond, reset further notice with a $1,500 SOB through pretrial. 19 is reset further notice with a $2,000 SOB through pretrial. 20 is going to the SAP calendar with a total $1,500 good bond. 21, reset further notice with a $2,500 SOB through pretrial. 22 is going to the SAP calendar with a total $1,500 good bond. 23 is reset further notice with a $2,500 SOB through pretrial. 24 is a consent bond with a $2,500 SOB through pretrial. 25 is going to the SAP calendar with a total $8,000 good bond. 26 is reset further notice with a $2,000 SOB through pretrial. 27 is going to the SAP calendar with a $1,000 good bond. 28, SAP calendar with a total $5,000 good bond. 29, SAP calendar with a $1,500 good bond. 30, SAP calendar with a $1,500 good bond. 31, SAP calendar with a total $1,000 good bond. 32, SAP calendar with a total $2,000 good bond. 33 is a consent bond with a total $5,000 SOB through pretrial. 34 is going to the SAP calendar with a $1,500 good bond. 35, SAP calendar with a $1,000 good bond. 36, SAP calendar with a total $2,500 good bond. 37, reset further notice with a total $5,000 SOB through pretrial. 38, SAP calendar with a total $3,000 good bond. 39, reset further notice with a total $3,000 SOB through pretrial. Position 40 is being reset to Friday, May 1st. 41, SAP calendar with a $1,000 good bond. 42 is being reset further notice with a total $3,000 SOB through pretrial. 43 is going to the SAP calendar with a total $5,000 good bond. 44, SAP calendar with a total $1,000 good bond. 45, reset further notice with a total $4,000 SOB through pretrial. 46, SAP calendar with a $1,000 good bond. 47 is a consent bond with a total $5,000 SOB through pretrial. 48 is going to the SAP calendar with a total $1,000 good bond. And 49 is going to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or otherwise?
I do. Miss, can I get the level for 47, please?
The level for 47 is, just a second.
That one was a consent, so I think it was level. What was the recommendation, Ms. Stallworth?
I don't know which Williams that was. Is that Jamar
Kevin
or
Lamar. Kevin Lamar.
His was a level 2 recommendation.
Oh, was
So what was the consent? We're gonna defer to brief pretrial. Can we strike that and make it level 2? All right.
Okay, let me ask this here because they wrote it up. Did you all put level 2 on your consent or do I need to change it?
You would need to change it. We put level 1 on the
Okay,
consent.
that's what I was thinking too.
Does
Okay.
that create more work for you, Ms. Bridgewater? But I do want to defer to pretrial's recommendation.
Okay, well, I'll do it. Have you
Thank
all
you.
sent those consents to me yet? Please
I
say
know
yes.
that one was definitely
Okay,
sent
I'll
to
change it. No problem. I'll change it to 2.
And can I get 33 and 34? I'm sorry.
33 and 34, what is it you need to know on those?
The 33, I know it was a consent bond, but I didn't get make sure the level was level 1.
I have level 1 for 33. Now, I don't know.
Someone is messaging me in the chat, which is not appropriate. If a victim witness advocate could speak with
Valencia Kelly, Ms. Tucker, or Mr. Sirocco, please put her in touch with somebody from your office. All right, is there
Okay, now
anything else?
position 33 was a consent bond level 1. And somebody mentioned position 34. I have that as a good bond, a surety bond.
Okay,
The
that's
amount
all.
is 1,500.
All right, thank you.
Okay, are there any others? Speak now, forever hold your peace. Okay, y'all, I think that's it.
All right, best of luck to all parties. Thank you all for your patience. Again, thank you for the consents and the hard work that you put in ahead of time. I did my best to get us out of here by 6. I was not successful. Ms.
Okay.
Bridgewater, I will be holding for you to send me those orders,
I'm
please, and
feeling good
anything
right
else.
now, Your Honor.
All right, take care, everyone, and have a wonderful afternoon. See some of you all next week. Take care. Bye-bye.